implicated under POSH Act. The senior Mr. Mukherjee was arguing this matter. It was partly heard. It was listed on 27/11/2024, but did not reach.
Leave this week, madam. It's very complicated. This week is
next week. Your Lordship may kindly give it next week, please.
Next week we'll see.
Any
day. This week is you are not sure what is going to happen. So let it be next week, huh? Next week.
Obliged.
Item 35 is the compromise. What is the formula? Also taken up.
Item
35.
you don't want.
No, Milord. Party has to be also taken up.
I'll take it up at 12.
Pardon, there's a fresh bail application, but previously my lord, we had another bail application. This was like this another. So
Give bail applications will come.
I will pardon, my lord. Item 76 and 77. Mr. Dolai, he is the arguing counsel. He has gone to Mumbai for his health checkup.
76?
76, 77. Any day next week, my lord. 12th.
Next week may not be possible.
12th.
We'll see and give it.
My lord.
We'll see and give it.
Item 15, my lord.
Wait, date we will see and give. Okay.
Item 15, my lord.
Yes.
Pray for
15.
15. 1-5.
Okay.
Item
Mr. Panda, the counsel for the petitioner seeks one more opportunity to explore the possibility of settlement. Mrs. Naidu, on the other hand, opposes the opposes. Mr. Panda voluntarily submits that his client would deposit further rupees 1 lakh, within
4 weeks. It's 4 weeks.
How much you testing her patience or what?
The 15 lakhs half must be fees, your lordship.
15 days hence. 15 days hence. Lease the matter for hearing and the
February.
second week, third week.
3rd week February.
And pay and finish it up. Yes.
My lord, I am having interim order to pass.
Interim order to continue. Yes.
okay.
Item 2.
Yes.
The petitioner, lordship, the owner of the Gosala, it challenges the revision order, your lordship, passed by the learned court below.
Sorry.
The revision that an illegal transportation of Gomata was there in Bhadrak, for which the police seized the 7 numbers of cows and 2 bullocks, and also giving to handed over to me, your lordship. I am the Gosala owner, and subsequently
I'll issue notice. Issue notice to police party.
miscase first, your lordship.
You are seeking what are the directions you are seeking?
Direction was to release the
Release what interim order is, that is the final order.
your lordship, unless the proper identification is there, how
That
it
would
is-
be the final relief. So I can't give without hearing the other side. I can't give final relief.
till that period, your lordship,
Till that period, what say? You know,
lordship, if police will come and it's harassing me to
it is there with you.
yes, your lordship.
The cattle are there with you.
Cattle with me, your lordship. There are
What do you say? What do you say?
2,000 cattle in my
Village your lordship also decided on it.
Or till the next date of hearing, stay. Impugn order is stay. Yes.
Item 3.
Let's say item 3, I prefer on adjournment. Let's say.
Adjournment. Mark.
There is no interim order. Let's say.
Interim order is there.
Let's say.
Then why should I adjourn it?
This is some personal difficulty.
What interim order? There is no interim order. There is no interim order. There is no
Interim
There is no interim order here. I have not passed any interim order. Where is interim order? Show me. Last date you requested for adjournment. I have adjourned
Next week.
That's all. No interim order. Adjourn it to March. Yes.
Item 4.
May I please, your lordship. My lord, the petitioner challenges order dated 29/4/2024 under annexure 7 at page 34, your lordship, wherein the petition filed by the present petitioner under section 437(5) of CRPC has been rejected, my lord. To cancel the bail of the accused persons have been filed before the court of learned.
What is the ground of cancellation?
Now, the ground of cancellation, your lordship may peruse annexure 2 at page 22.
Just tell me.
the order obtained from this honorable court in anticipatory bail has been suppressed and
Okay.
there is a ground to deposit cash, cash of 3,000,
That is also.
which has been circumvented by the accused, my lord.
Okay, issue notice. Issue notice to opposite parties. Yes.
Item 5, Your Lordship, we have prayed for this investigation to be handed over to the CBI. Yesterday, we had filed the rejoinder, but it has not been generated in the
What
system.
is this case is about? Just see.
Your Lord,
Charge sheet has been filed.
sir, charge sheet has charge sheet they have prepared, but
This is a case.
let me complete. Your Lordship,
Yes, yes, yes.
Lordship, it's a case of murder.
Hmm.
The deceased was
You
a
are the
20.
informant.
I'm from the informant. I'm the informant's mother. Deceased daughter was a 23-year-old engineering student. A case was registered under 302, but what the police had done is that they had arrested the accused person and later on released them on a 41A bail, Your Lordship, because the accused father was serving as a then joint secretary at the Home Department. As a result, entire investigation has already been suppressed. When the dead body was recovered, the then SDPO had communicated to the deceased mother that it is a case of murder, as there was a ligature mark in the middle portion of the neck. Yesterday, we had filed the rejoinder, but it has not been generated.
Okay, by the way, they filed charge sheet.
They have not yet filed charge sheet. They are not submitting it.
Then also have filed the objection to the petition manner or not objection as per your lordship's director manner. File the affidavit, the stage of the investigation. And in the stage of the investigation, the lordships may kindly see the affidavit dated
Yes, you just tell me.
the drowning, she was dead, died due to drowning. A life detection test was made and there is no proof found. For which matter he has stated that investigation is still progress and the evidence to frame charge against the suspects or any other culprit in this case, further investigation is going on.
Named FIR.
FIR he has
Named.
2 persons he has named.
Lordship,
Let the rejoinder come. We'll see.
Lordship, yes.
Judge, if it is a named FIR and 302,
Everything they have.
why have you given 41 notice?
If your lordships will go through that affidavit, my lord.
Yes.
They have taken every aspects, my lord. The cause of death is the drowning. Then they have the foul play. They have taken the CCTV and other things. They have not found any clue, my lord. Still, then they have, the investigation is open, my lord. They have not proved
Who is investigating now? It's
the DSP was investigation at the
local police.
Set up highly the norm. Now we are in 11.
Your Lordship, the offense was
We'll see.
offense was, Your Lordship, just only 1 minute I would like to submit, Your Lordships, only 1 minute, Your Lordship. The offense was registered in 2023. In the post-mortem report, the doctor has not stated whether the cause of drowning is antemortem, whether it is suicidal, accidental, or homicidal. They have not stated. Number 2, in the counter affidavit submitted by the Learned State Council, they have stated that an ethyl alcohol was present. That's number 1. Number 2, in the left lower side of the breast, there was 6 number of red marks, which clearly indicates there is a suspicion and foul play being committed by the doctors concerned. That's why, in this case, taking into the consideration the rarest of rare category, we have prayed for the investigation to be handed over to any independent agency.
You filed the rejoinder.
We had filed the rejoinder, yes.
Okay.
Yesterday it has been filed. We will supply. We'll supply. We'll supply, Your Lordship.
I also instruction.
Kindly, the matter be taken up next week, Your Lordship.
Not next week, we'll give you it. Yes.
Yes, Your Lordship.
Next.
Item 6.
May I please, my lord? My lord, petitioner challenged the criminal proceeding initiated against the petitioner. Informant is the father and petitioner is the son. FIR was lodged on 4/1/23 against the petitioner under section 307 and 328 of IPC. Around 1 year, 10 months have been passed. Police have not been submitted the charge sheet.
Yes.
Informant.
In the meantime, my lord,
You are for informant, you are for the petitioner.
Yes.
Accused, huh?
And amicable settlement,
Petitioner accused.
father is present here, my lord.
and amicable settlement has been made between the parties, father and son.
307 matter, no injury for nothing matter.
Nothing is filed also.
My lord.
Tell me what is the injury?
Fact
Nothing
is
is
that
there.
the elder son of the informant taking alcohol every day. On that particular day, he was excess drunk, and for which informant thought that younger son has
Administered poison on him.
But you have to tell me what is the stage. Have you got anything? Or otherwise I'll quash it.
Charge sheet yet to be submitted, my lord.
You give me some information. File the status report.
My lord, father is present here.
informative here.
Maybe, but I
Father
need
and
to-
son both are present.
I need to know what is the position.
They have not submitted anything, and we have also not, I has also not yet submitted the.
Get the CD. Get the CD. Because except FIR, nothing is there.
My lord, fact is that 1 year, 10 months have
In
been
fact,
passed.
only I want to know from the police.
Last occasion.
307, I
last-
know, but at least you should tell me, get the
fact
injury
is-
report or something. Nothing is there. How can I quash it like this? It's a case of 307. Neither he is filing nor you are filing. Except FIR, you have not filed anything.
Nothing is there, my lord. Family dispute between our eldest son.
There is no affidavit. There is nothing.
No, affidavit. Here is the affidavit.
No, you place everything on record. You get the status report. You don't make 482 court so casual.
No.
Except on FIR, nothing is written.
Lordship, pardon, my lord. Last occasion, your lordship directed me to produce father before the court, giving an affidavit. In
That injury, at least I should know what are the injury, what is the.
no injuries is there, my lord. Nothing is there. Only the allegation is that he has taken poison.
Why? How can I believe you on your oral statement? Nothing is there on record. You show me in your petition where have you said.
No, that is not.
Then neither in the pleading nor document, nothing is there. At least something has to be. At least you write in the petition. In the petition also you have not written. It is a 307 case. Except FIR, you have not filed anything. And in the pleading also, in the petition also, you are not saying that injuries are
Allegation
simple.
is that poison has been administered. That is
Poison
the.
is found or not, let us understand.
I say, I want it. No.
Poison was found in the medical examination.
My lord, father is present, my lord.
Like this. Next week request. Get the status report. Yes. At least you file something. If I'll see the affidavit, the same kind of affidavit. We have settled the dispute, quash it. Except that you might not have written anything. One paragraph. What kind of affidavit, what kind of petition you file? How can I entertain?
My lord, the reason is this, and father.
Where a reason orally you are saying.
Yes.
You show me in a piece of paper whatever you are saying is reflecting. Either in the petition or in the affidavit, anywhere. What is it?
Today is filing the affidavit.
Yes, 7. At least in the petition you should write. Yes. We'll see. They have to come. Yes. Yes, next.
May I please, Lordship? Lordship, in this case, my prayer against the Annexure 2, Lordship, that is 10/3/2017. Lordship, Magistrate has been taking cognizance against the present petitioner, Lordship.
Yes.
In this case, Lordship, one present petitioner and one Vijay Kumar Agrawal, they are the transporting agent of MDM rice in different school, Lordship. As per allegation, both of them manipulating the delivery channel and not supplying the rice to the different in the school, Lordship. The fact is, Lordship, in this case, similar type of 3 cases has been lodged against present petitioner and Vijay Kumar Agrawal, Lordship. Lordship, in this case, kindly have a glance. In two cases, charge sheet has been submitted, Lordship. Present petitioner name is deleted, Lordship.
You are Santosh.
Yes, Lordship. Santosh Agrawal.
Yes.
In this case, present petitioner name is there, Lordship, in charge sheet. But
Yes.
other 2 cases, present petitioner name has deleted, Lordship. In similar type of case,
And in this case, only cognizance is taken. You
Yes,
tell me in this case why cognizance order has to be quashed.
Lordship,
Because in some of the 2 matters, your name is not there, doesn't mean
yes,
that.
Lordship, but kindly have a glance, Lordship. Similar type of 2 cases, Lordship.
That's right, madam. In that case, you are not the accused. It's all right.
Yes,
I
Lordship.
accept that.
But Lordship,
But that can't be a ground for quashing cognizance of order.
Lordship, the 3 cases, that is same offense, same allegation, that is
You don't follow me what I.
yes, Lordship.
There are 3 cases raised.
Yes, Lordship.
You are saying in 2 cases you have been exonerated.
Yes.
So therefore, the third case where cognizance is taken,
Lordship, but,
that also should go. That's what you are saying? But I have to see in this case whether any material has come against you or not.
Yes,
You
sir.
satisfy me that there is no material against you in this, insofar as this case is concerned. You should be happy with that two cases you are
Not just it.
not charged with.
No,
Or you want that
In this
further
case-
investigation should be done in that case. You read this case and tell me.
nothing.
You read this case. If you are not prepared, I am ready to give you time.
950 kg.
Yes, Lordship, but this case is pending since 2000.
NBW has been issued. He might not be appearing. Vijay Kumar Agarwal, NBW has been issued against him. He must be absconding.
I am the Santosh Kumar Agrawal, Lordship.
I know he must be
Yes.
absconding. Therefore, nothing is moving in this case. You better you argue all these points.
Trial has been not commenced, Lordship. Kindly.
point raise करूं.
They raised all these points for the trial court.
Right. Petition is agreed by the order dated 10/3/2017, whereby cognizance of offences punishable under section 465 or 468, 471, 409 IPC was taken against the present petitioners along with other accused persons. The model for the petitioner submits that on the exactly on the same allegation, 3 cases were launched against the petitioner and the co-accused person. In 2 cases, he has been exonerated on merits. However, in the present case, the petitioner has been falsely implicated. Therefore, she challenges the Cognizance order in the present proceeding. I have perused the allegation against the petitioner made in the FIR and the charge sheet. I'm not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to raise all the points before the trial court at the appropriate stage. With this observation, the petition is disposed of. Yes. Next. Oh. Yes. Yes.
Here I challenge the order of cognizance.
Annexure 2, madam.
Annexure 2.
2, madam.
Yes.
These are page
Yes.
70.
Yes.
Cognizance was second on section 420, 506 and 34.
34. Yes.
Here I have challenged because the entire offense does not disclose any cognizable offense, and if the entire story is taken into consideration, then it is civil in nature, and there is no cause of action. Your Lordship may kindly come to case here.
This is arising out of a complaint case.
Complaint.
Yes.
Fact is that, my lord.
What is your name? Name is?
Complainant opposite part number 2, my lord, is the father-in-law of the petitioner.
Yes.
He forcibly gave his daughter in marriage to the present petitioner, and the girl is very upright girl. He disclosed that against my will, the marriage is given. After 15 days, she left without giving any information.
Yes.
Only she told that I no longer I will stay.
I am not interested. Yes.
I will pursue my career, and my father forcibly gave him the marriage.
Yes.
Thereafter, they filed the joint petition, and divorce was allowed. Thereafter, the father has filed this.
What are the allegations here?
Allegation is, my lord, he has paid some amount to the present petitioner and his family members. That is the only allegation.
14 lakh.
Yes, my lord, your lordship may kindly see.
Page bar.
Page 12.
But NEFT he has done bank transactions.
Bank transaction, my lord.
Then
Before the marriage,
why have you taken that money?
my lord, to make payments, he has purchased some jewelry and other things to Rautela.
Yes.
Petitioner is serving at Rautela. He is a well person, my lord. He has never taken any money from me.
No, he has transferred through bank transaction.
Yes.
NEFT.
Towards the payment. For payment of.
Payment of what?
The father purchased some jewelry, my lord.
Father
For
means
the-
your father.
No, opposite number 2. father-in-law of the petitioner.
But it is transferred to your account.
Yes, my lord. Because procedural.
So that has to be established.
Yes.
For what purpose it was transferred?
Yes. my lord.
It is all bank transaction. He is
Bank
making allegation on the basis of
Yes,
bank transaction.
bank transaction.
So whatever you are saying, those things are the defense.
My
It
lord.
has to be. It has to
Till
be
then
proved.
it is civil. If it is accepted, my lord, it is civil in nature, my lord. Your lordship may kindly say entire allegation, my lord. Here's first I will bring your lordship to page 11, my lord.
There are allegations, not that there is no.
Yes, there is no cause of action, my lord. At page 10,
Before marriage, you have taken the dowry
no dowry.
and just see page 12. All the bank details are 4,40,000 rupees. Check
Yes.
paid, RTGS paid,
Yes, yes,
and
my
4,80,000 rupees paid. Like this.
Yes, my lord, he purchased some jewelry. Payment was made through the petitioner, and the daughter of the opposite party number 2 has already taken away her jewelry. She has stated in the.
No, all these things I can't go into at this stage. There are bank transactions.
Yes, my lord, if it is accepted, my lord, it is a civil case, my lord.
How it
criminal
is?
case?
You see,
Rather-
thereafter just see the allegations.
Yes,
It's not civil. See the allegation. You have threatened also.
that is.
I have already
Yes.
divorced your daughter. Nothing doing.
I am bringing your lordship.
And all these, just see
the cause of
the
action.
language you have used.
Your lordship may see the cause of action.
No, I don't think I can entertain.
Yes,
I was
yes.
thinking it's matrimonial. It's all right. Just see, come to page 13.
Yes, my lord.
13. Allegations are there.
He has alleged, my lord. I don't deny.
That allegation, at this stage only allegation would be there. You have to rebut it by bringing evidence.
My lord, your lordship may kindly say why I have challenged, my lord. Your lordship may kindly see the
See,
judgment.
I have to see whether prima facie case is made out or
Made out.
not. Prima facie case is made out.
Yes, my lord. Your
You
lordship may
want me to write all these things? I'll write it.
Yes, your lordship may kindly see the judgment. Page 19.
What judgment is this?
The divorce was allowed.
Yes, I know that. You have
Yeah.
been, divorce has taken place. But
Yes.
before divorce, you have taken money.
The girl has stated
And thereafter, you are.
in paragraph 2,
threatening.
my lord. In paragraph 2.
Anyway, I'm not with you. Just think over. You withdraw it and
If your lordship will not go through, listen me, my lord.
I am listening. I have read it also.
My lord, your
What am I
lordship
doing
may
then?
see the probability. Your lordship should see the probability.
The probability will be.
I don't deny it.
On the basis of probability, I can't cause a criminal proceeding like this. Allegations are serious.
No, not
You have
civil.
all-
Allegation is civil in nature. Your lordship may.
Bank transactions are
Your
there.
lordship may-
I'll write a judgment there.
Your lordship may-
I'll write a judgment.
Yes.
Yes. Keep it. I'll write a judgment. Yes. Next.
Person to my lord's last order has not come. My lord, instruction has not come. Lordship said that it is civil in nature or 120 is made out or not. Your lordship
Yes.
last.
Get the report then.
Ma'am.
Get the report. Pursuant to the order dated 29/11 to 2024, the State Council has not received the status report as yet, hence seeks an adjournment. Please the matter.
Next week, ma'am.
Next week or next to next week. Let us see. I'll adjust and give it
Subject to my lord's.
before vacation. I'll try.
Ma'am.
Yes.
So grateful.
Yes.
The petitioner prayed for a direction to early disposal, 1CC case number 109/2000.
Who are you? You are the complainant.
I am complainant, madam.
Okay.
109/2023 pending for SDGM Puri, my lord. Pleadings are complete.
Payment of wages.
Payment of wages, madam.
Yes.
Your Lordship, I'm appearing on behalf of TPCODL. We have instructions to appear for.
You are the management.
Yes, Your Lordship.
Huh.
We have instructions to appear in. This
He is only asking for expeditious disposal.
Expeditious, yes.
Yes.
He's not asking anything.
Huh.
See, this case is pending to 23 only. 2023. 23.
My complainant is a senior citizen, man, after retirement. Non-payment of just file the payment of.
The statute provides time-bound disposal.
Yes.
Payment of wages check. Just see payment of wages. Does it provide timeline? Does it provide timeline for disposal of these kind of cases? Have you seen it? Yes, no, something you have to tell.
Yes, ma'am.
Tell no if you have not read it. I'll give you time. Because there are special statute prosecutions. In the special statute prosecution, generally time frame is given. Timelines are given in the statute itself. Have you read it?
Next.
March.
Lordship, a copy of the.
Copy
xerox
will
will be
kept
sent.
March 4. Yes. And 12.
Madam, only for expeditious hearing.
I want to know whether there is a statutory provision or not. You have not read it. Yes.
Okay.
Item 12, apply for next week because you also see that on the ground of compromise matter is like 2 class. You have to direct the personal actions of both the parties.
Sorry? What are the
376 and other elements.
17 and
376, 506 and everything is there?
Yes, Your Lordship. And petition is the Afghan Lordship since 2014.
The informant, both are held from a civil tribe family from Sunavada in the district of Nuapara.
That's right. Whether they settle, married.
Yes,
They married. 376, have they married?
In fact,
26, 38. The girl is 38.
Paragraph 6, my Lord,
Boy is
there is
26.
mentioned.
in fact,
Dispute has been resolved between the parties. Paragraph 5, page 5,
In the
paragraph 6.
tribal area, this quite often happens. What to do?
one will appear, both are appear
Okay.
today, but it is
I'll
not
just
appear.
adjust.
Keep
I'll
it next week any day. On
Simply
that day,
adjust it. Try to adjust.
both will appear, my lord.
Yes.
Either through in person or through the VC at
Yes.
Nuapara. my lord.
Yes.
If you kindly observe that, or through the VC at Nuapara.
No, I will not. I will not be a party to your settlement. You bring them,
No,
I'll
not
record
settlement.
it.
Either
And you will show that the court has asked you to go on
no,
appear. No, I'll not do
The
that.
VC court.
If you have settled the dispute, bring it.
Yes, yes.
Both of you should come. Why should the court be a party to your
Your
settlement?
difficulty is, yesterday I told the advocate from Nuapara bar, he told that unless a direction there, the VC.
No, why should I direct?
They will not allow to appear
Let
to
it be.
VC.
That is your problem. If you have settled the dispute, you have to, both of you have to file joint affidavit.
Yes, joint.
Come before the court
Yes,
and tell that you have settled.
Yes, yes.
Not that court will
Yes,
be a party to
no,
that.
it is
No,
all right.
court will never be a party
No,
to
yes,
court.
it is
Yes.
all right.
You bring, I'll.
Next week, any or
Yes, yes. Next.
May I please, my Lord? Lord, this CRLM's application related to.
The tribal people don't know.
Yes.
They'll say that no court has asked you and go and give statement. And that's what happens. They'll come their court book.
No, they are quite cautious of
No. I know.
pendency of the case.
I belong to that area only. Don't worry.
Other family members, they could not even go.
I belong to that area. I know.
No, I'm aware of the same.
What happens? Mr. Party must be knowing more than. Yes.
May I please, my Lord?
Yes.
My Lord, this CRLM's application related to release of the vehicle under section 52A of the NDPS Act, my Lord.
Yes.
I have a glance the page 14, my Lord. While disposing the petitioner's application, that is observed by trial court, my Lord, for release of the vehicle in question, the petitioner is no more survives, my Lord. And while considering the similar type of case,
Hey,
my Lord.
this is an application under
Is the applicable, Your Lordship?
57.
Not applicable. Mukauch. And this is the
Then
lordship's.
you have to challenge this order by any revision.
No, my Lord, they have not entertained. Someone entered after rejected, say.
Your application under 457 is rejected by the magistrate.
Yes, my Lord.
Then you have to go in a
Not
revision.
entertained by the.
Whatever. Either it is rejected or allowed. Revision lies against that. 482 revision lies.
While considering this type of case, my Lord, that is a lordship's order. Lordship has observed that in paragraph 4. However, the present petitioner is seeking release of the vehicle on Jimanama, with certain conditions as may be deemed fit and proper. Therefore, the court below has inappropriately applied the ratio of the said judgment to the present case. I also ready to take the similar order.
No. Just see. That's in NDPS case.
Yes, yes, my Lord.
This one?
Also NDPS case.
But this is an order passed by the SDGM.
That is SDGM.
That order is passed by
SDGM Koraput, my Lord, in paragraph 5, my Lord.
yes.
Praying for similar order, my Lord.
Just see. Just see.
Yes, I have just now received the copy of the order, Your Lordship, but it is the.
I issue notice, just check
Yes,
it up.
yes.
Huh?
Yes.
Check it up. Issue notice. Because that this order is also for SGM order. Yes. If you notice, check it up and tell me.
Lord.
Yes. Yes.
Item 14.
Whether similar order could be passed. My lord.
Before starting my learning senior lordship, just yesterday night I have received the brief copy of the CD lordship. I will go through the same lordship. Next 14 terms. Bulky documents.
Give him the benefit of.
I don't dispute. In fact, coincidentally, I was also going to make a prayer that to indicate the name of Mr. Senior Counsel, Mr. D. That the appearance memo was filed. And he has got some difficulty because of the marriage purpose. I was also supposed to pray for
He has preempted you.
In my learning is I'm very much thankful that he has solved my purpose. My learning is paragraph 22 is clearly mentioned that can be taken at the time of framing of charge. But due to so many accused persons are there, it is not practicable on the part of the present prisoner to issue all at the point of charge.
Well, especially you can move an application. Who stops you?
No, my lord.
You move a separate application.
No, that I can't.
Okay, I'll hear.
Because last occasion, your lordship, it was my submission. I also made a submission on the last occasion on the 4179. That admittedly there is a stage for me to raise on the time of framing of charge. There are numbers of transporters, so many persons. The appearance process has not yet been completed. So I am in difficult. I am an owner and driver as well as the transporter. We are not able to enter into the drive. The transporter is not able to sign any MOU because nobody is coming to sign MOU to use the transport service because of this criminal case. And being the owner and drivers, we are not also being able to hire our vehicle in reputed organization to some.
Because
so therefore, the entire case rests upon one document that is admitted in the charge sheet, that is available in charge sheet. IO gave his opinion. If you have lordships for kind, just
I'll hear you.
I'll
hear you. I understand.
For transit pass through. चारिटा फोर्स वाला गोटे जेन्युइन जो गोटा जेन्युइन आमरी
अच्छा
so I pray before vacation any day
23rd 24th yes
And 16.
My plea, your lordship. Petition under section 311 CRPC has been rejected, your lordship.
Yes.
On 6/8/2024, the case by 6/8/2024, your lordship.
Item number 16,
yes lordship please
yes.
On 6/8/24, date was fixed for hearing. On that date, PW 1 and 2 were examined in chief, your lordship. Due to absence of the defense lawyer, they could not be cross-examined, your lordship.
Where is that impugn order? 110?
1 and 2, your lordship.
110/24.
yes your page 30 your lordship
30.
yes
My lord.
starts
Due to death of mother of the conducting law, your lordship, say funeral ceremony thila.
You want you seek
1 and 2
recall of which
PW 1 and 2.
victim and
where is your application? I'm searching
Application I have not annexed, your lordship, in this. The fair copy is there, charge sheet and some certificate and
you have not filed the relevant documents. Where is the application at 311? Where is the testimony? Where is the evidence recorded?
Totally cross-examination hai nahi.
How will I know?
Matlab,
show me at least. Let me see that.
That on that day the chief has been done and they were
evidence. That's what I'm saying.
That is your lordship in.
It is a case of rejection of 311 application.
Page 20.
Neither 311 application is filed, nor the testimony of the witnesses sought to be recalled, not filed. And you have filed charge sheet, FIR,
within
Deen Dunia ke sab kuch.
Within 1 month, immediately after function.
Show me this evidence.
Page 29 they mention after examination in chief.
Show me the evidence. I will not like this.
Evidence copy.
Both whether you have refused to cross-examine?
Not refused. Due to absence of the defense lawyer could not be cross-examined. So refuse karini.
Show me application at least.
Application to
311.
Application to nahi. ଆଉ ଗୋଟେ ଡେଟ୍ ରଖନ୍ତୁ ମୁଁ ଆପ୍ଲିକେସନ ଆଣିକି ଆସିବି ଆଉ।
What is the relevancy of FIR here? What is the relevancy of charge sheet? It is a rejection of 311 application. The application is not there, the deposition is not there. And you have filed so many documents which are not relevant. Whether in the application, whether you have proposed the questionnaires or not.
मतलब टोटली क्रॉस एग्जामिनेशन ହେଇନାହାନ୍ତି।
Okay, then you show me the cross examination was afforded to you, you didn't do.
मतलब on that day junior lawyer was present and the conducting lawyer
Have
was,
you taken these grounds in the application?
मतलब formal application has been filed for recall, your lordship.
Oh, and you are filing some funeral ceremony.
Well, that is true, your lordship. That is true because of absence of the conducting lawyer, your
So
lordship.
therefore you give me,
junior lawyer cross examination.
give me the application right
My lord.
right now. I don't need.
My lord.
It need not file. You give me, I'll allow it now.
My lord, mobile ରେ ଅଛି। My lord, ଅଛି your lordship.
Release it January. Yes.
My lord,
January. Yes, next.
your lordship kindly
I
after
can't
launch.
help you. I can't help you. I'm trying to help you, but
Yes, lordship, I will produce. My lord, certified copy I will produce in the
18. Yes.
my lord in the
January.
my lord next week, your lordship.
No, not next week.
Kindly, your
Not
lordship.
possible, sir.
My lord said
It is so difficult to list it. You don't understand.
your lordship.
No.
My lord, only two witnesses.
And I will just pass it over, get the application.
My lord, pass it over. I'm coming, your lordship.
These are minimum thing. Why are you wasting time of the court?
Please, your kindly excuse me. Your lordship.
Next.
My lord.
Pass over, get it, get the application.
My pleasure, lordship. My lord, the impugned order is that annexure 1C, my lord, by the impugned order, NBW has been issued, my lord.
Yes.
My lord, the petition was extended the benefit of 205 CRPC, my lord. Thereafter, for a wrong date of posting on the date fixed on.
Where is that order of NBW?
My lord, annexure 1C, my lord. Page 1C, page 16.
16.
My lord. My lord, on the date of.
I'll set aside it. Set aside it in Gond APR.
But may I pray one thing, my lord, it's a monetary transaction. If your lordship issue notice to the opposite partner to the complainant.
NBW I'll allow your petition. Why should I?
It can be settled here.
This is not.
Therefore, I am saying.
For you, if you want to settle this, should you settle that? Yeah. Then petition is agreed by the order dated 11/3/2024, whereby non-bailable warrant has been issued against him for his absence. He has challenged the said order on various grounds. The petitioner petitioner is an accused in ICC case number 9 of 2019. 2019. What are the offences?
138 NA Act.
Initiated by opposite party and 130 NA. For the reasons stated in the present petition, the petition is allowed. The NBW issued on social the petition is directed to appear before the court on or before 30th of December and be sure to be remedied allowed. Yes.
19 and 20 also same. Impugned order date is also same.
19 and 20 both allowed. Yes.
Number of complaint cases.
Complaint case is different.
Both all are allowed. Yes.
21.
May I please, your lord?
Yes, sir.
This is for quashing the cognizance taken in the PMLA Act.
Yes.
No, there are 4 grounds. One, my lord, the vigilance case, which was initiated on the basis of which the PMLA Act case was registered, that vigilance case has been quashed by an order dated 23/9/22, which is at page 63.
63.
63.
Okay.
My lord, a bench of this court quashed the entire vigilance case, whose charge sheet has been quashed. Page 63.
That's the predicating office. The predicating office goes.
Then let my single complaint I this CRLM has been filed without with suppression of facts. Similar applications were filed before the special court And those are pending till date, your lordship kindly.
No, but you predicating offense goes, then why should you?
Predicate offense has not gone. Predicate offense, your lordship kindly see page 63.
I'll show, my lord, can I show
Yes.
two things?
Yeah,
Two things,
yes,
just the
yes.
two things it will satisfy your lordship.
Yes,
Lord, this has passed, the scheduled offences has been passed.
was.
The Supreme Court, your lordship knows in 22, Justice Khanilka judgment that it goes, it has.
Goes,
to
everything
go.
goes,
That's-
yes.
Now look at their own complaint. Look at their own complaint.
Yes.
Look at. That, my lord, if your lordship turn to their own complaint,
Annexure 1,
Annexure 1, look at page 20.
20.
20, my lord.
Yes. Yes.
An investigation under PMLA was initiated by Enforcement Director Bhubaneswar, Subjournal Office Bhubaneswar against Sirajuddin and Company. For alleged commission of offence under Section 3 of PMLA on the basis of the charge sheet number so and so, charge sheet number so, both filed in the Court of Special Judge Bhubaneswar Baleswar under Section so and so, the prevention of so and so, arising out of FR number so and so, FR number respectively registered as Vigilance PS Baleswar Odisha relating to manganese ore at Gurdwara. The said charge sheet revealed commission of punishable offence under Section Prevention of Corruption Act, Section 20371, 420, 120B, Section 21 of the MMRD Act, Section 2 of the Indian Forest Conservation Act, committed by Mr. Sirajuddin. The offence punishable under Section 420, 120B are schedule offence as defined under Section 21 of the Act.
Yes.
Now look at the next page, 21.
Yes.
Brief summary.
Brief summary.
The complaint submits that the condition precedent to investigate the offence of money laundering.
Again related to the same FIR.
Think there is no dispute about that.
How did it come?
Okay, sir. Subsequently, Milord, supplementary charge sheet has been filed. That's why I submitted at the beginning, Milord, this CRLMs has been filed, but suppression of facts, Milord. Subsequently, supplementary, your lordship kindly see the order sheet. Subsequently, supplementary charge sheet.
After the order of judgment of this court, quashing the
Yes,
proceeding.
Milord. Yes.
173, it was open.
Yeah,
No.
Milord, entire
If
entire
170,
schedule offence has not been quashed.
no, if 173.8 is not open, how have we proceeded?
No, it was open, Milord.
Show me that.
Your lordship
Show me
can
that.
see that complaint itself.
Yes.
Supplementary complaint was filed.
Complaint.
Yes.
Not
Supplementary
charge sheet.
complaint.
That's
Wait.
Not charge sheet.
Then 173 question doesn't.
173 is open, Milord.
Yes.
Because the complaint, as Supreme Court said, complaint itself in the PMLA Act is like a charge sheet.
No, that's right. That there is no doubt about it.
Yes.
Correct.
But once the predicating offence is quashed, you can't file a supplementary
There are number of.
only to sustain PMLA. You can't keep on filing the
Also,
complaints.
Hear me 1 minute.
Yes.
The schedule offence has not been entirely quashed. It was quashed with respect to only one accused. That's why I was pointing out, the lordship kindly see page 63.
63. Yes. Yes, 60. Yes.
The lordship got to be.
This is okay.
MD Muzaffarur Rahman, only with respect to this accused it was quashed.
And another.
Please, sir. And in the meantime, this accused has died, his name has been deleted, Milord.
Okay.
Subsequently, proceeding under schedule offence is going on. Entire schedule offence has not been quashed. The lordship see the last operating portion of the order. And the same application.
Then come to page 120. 120.
Yes.
Para 19. Why does the court say that in the result CRLMC is allowed and the impugnator did so and so, qua the petitioner
Yes, Milord.
as well as the consequential proceedings
There were two
against them quashed.
Milord, in that, there were two, there are two vigilance schedule offence FIRs. 63 is one.
And then look at 125 also. In pursuance to this, the subject, the session judge has quashed it.
Yes, I am not saying that.
Against both.
Both. Yes, there were two schedule offences, two FIRs.
Both the
Under
FIRs.
schedule offence.
You file reply.
Yes.
It needs to be.
And Lord, the very same application, they have filed since 2023 before the special court is pending till date.
No, that has been withdrawn. That has been averred in the petition.
You file a counter. We'll deal with it.
Yes, let him file a counter. If the schedule offence.
Notice, Mr. Agarwal accept notice. In the meantime, you move application for adjournment.
That,
Yes, yes.
moving at that since 23.
It is open to the petitioner to move application before the court below or seeking an adjournment owing to the fact that matrix of the.
2023, they are moving application and court is granting them time. Your lordship, see the entire.
Why you are opposing?
If your lordship pass.
No prejudice to you. As it is taking it, keep on.
Because your lordship knows my verdict. Since 23, they are going on time. Your lordship.
But it needs, see, the part of the offense has been quashed. You are filing a supplementary complaint only to sustain your PMLA. All these things need to be.
Types of accused.
Yes.
Here, entire schedule offense has not been passed, only with respect to two persons.
Let us examine. Let us examine.
Yes,
If the basis goes, everything goes.
that's true. Otherwise, regarding proposition of law, my senior said there is no dispute. But here the facts are completely different.
So we have to decipher the facts of the present case with the cases which has already been quashed. Let us see, understand. Yes. Next.
With pleasure appearing before law.
Yes.
Lordship, fixing any day.
Mr. P.M. Mishra with CORAM.
My name be also indicated in the list.
Your presence is your name.
Lordship, fixing
Agarwal,
date.
Mr. Agarwal, accept.
Lordship, fixing date.
How will fix a date? Let him, how much time will you take? 4 weeks. Huh? 4 weeks. Let him. Yes.
Lordship, in this case, I have challenged the order dated 7/11/24 passed by learned Sessions Judge Kendrapada in criminal appeal number 16 of 24 in rejecting the application filed by the petitioner accused for grant of exemption from the deposit of 20% of the compensation amount.
Yes.
Lordship, I have challenged this on the ground. The learned Session Judge Kendrapada has not taken note of the fact that the check was a non-CTS check which was issued in 18/3/2013 has been rendered to be invalid and out of operation by July 2013, Your Lordship.
What is
the check was presented in the year
non-CTS? What is
2015.
non-CTS?
Non-CTS, my Lordship, it cannot be truncated.
That's what you are
Lordship,
relying upon a
Lordship, there are a lot of ground. Lordship, there are a lot of
newspaper.
ground. In fact, the complainant has not proved that there's any legally enforceable.
But you have been convicted. Area appeal is pending.
Lordship, my challenge is only to the grant of 20%.
You do one thing. You pay. What is the check amount?
14 lakhs.
Check amount?
14 lakhs.
Compensation?
For the informant.
Compensation?
14 lakhs, my lord.
Compensation is also 14 lakh?
My lord.
Okay.
Lordship, even the name,
My lord,
the
Inspector
beneficiary
for-
named in the check is not.
Inspector for several.
Not even the beneficiary named under the check. That's the first dispute.
You pay 10%, and for the
Lordship,
remaining
I-
10%, you
Lordship,
move application.
Lordship, he is not in the.
That is
entire
standard
trial.
order.
Lordship, in the entire trial, he is not even, Lordship, I may take your Lordship attention to
Not a single
page
file
number
deposit.
28, page number 28 of the brief.
Yes.
Lordship, this is the evidence. In his entire evidence, he has not been able to prove that this debt is due to him. Neither he has been able to prove from the evidences that he is even known to the complainant. Well, Lordship, this creates a doubt.
Why have you issued the check then?
Lordship, I have not issued the check. It is per chance that he has landed his hand upon the check. Whereas in his deposition, he stated that he doesn't know me also. He's not, he has
Show me,
stated.
show me that part. He
Lordship,
doesn't know.
Lordship, Lordship.
Yes. Show me that part.
Lordship.
Rather, you come to page 28, para 2. 28 para 2.
Lordship, he has stated that, but he's controverted it. That we are businessmen.
See, he says,
Lordship, his
I am the
statements
complainant
are-
in the present case, and I have been, it says that I, along with the accused person,
Lordship,
had a
his
good
cross-examination
relationship.
is controverted.
And both of you are businessmen.
Lordship, in his
You
cross-examination.
say, I don't know.
Lordship, one.
Yes, yes, of course. He says that you
Lordship,
are-
before I go to the evidence, I would like to take your
So
Lordship's
that
attention to
would have been
excerpt-
that would have been a settling
Page
fact.
27, your Lordship.
27, okay.
Page 27.
Yes. Check.
The check is named as Surya Kashinath Sahu.
Hmm.
And Kashinath Sahu is the complainant. And Kashinath Sahu says that Surya is another person working in the same company. Working, he knows the person, Surya. So how can
Where is that?
Lordship?
Where is the complaint? petition?
Lordship, can I take
Where-
your
where is-
Lordship attention to para 13 of the cross-examination at page 31.
Where is the complaint petition?
Lordship, I don't have the complaint petition. I filed the cross-examination, which is at page 31.
31.
31. Para 13.
Yes. Yes.
In the year 2014, the accused had a truck. The truck was not engaged in my business transport. I knew Tushar Kant,
Are you holding the copy of complaint?
Lordship,
Do you have?
No, sir.
Just show me. Complaint.
petition.
Do you have that complaint? You have notice issued by him.
Lordship, may I-
That's why I am telling you. There is,
I have all the facts.
no, there is a
That
reason.
was-
I'll tell you there is reason. You just tell me that.
Yeah.
Just see the check.
Lordship,
Check is Surya
Kashinath
Kashinath
Sahu.
Sahu. Okay?
And the check is dated in the year 2015.
And you have implemented Kashinath Sahu. Kashinath Sahu, Surya Kashinath Sahu, they're two different persons.
Two different.
Two different persons.
So the
In the
beneficiary-
complaint, what he has written? Kashinath Sahu or
Kashinath Sahu.
Surya Kashinath Sahu?
Lordship, Kashinath Sahu.
Then you have a case. Yes, sir. Check was issued to Surya Kashinath Sahu. Okay? And you to show me in the complaint what you have written. Whether you are Kashinath Sahu, Surya Kashinath Sahu.
It will decided at the time of
No,
hearing of the
Then
appeal.
Prama facie he has a case.
Let it come next week, I will satisfy, man.
Show me the complaint.
Lordship.
Show me the complaint because complaint is filed by him. In the complaint, what he described himself. Kashinath Sahu or Surya Kashinath Sahu?
Lordship, he has deviated from what he's written in the
I
complaint.
am asking a very
and in the
pertinent question.
cross-examination.
I am asking a pertinent question. You answer to those questions.
Lordship, let it come next week then. I can
If he has written in the complaint that Kashinath Sahu, then
Lordship, in the
gone.
complaint, I am sure he's written Kashinath Sahu. I do not have it at the moment with me, but I'm sure he's written Kashinath Sahu.
Show me the judgment. Show me the judgment of the trial court. Show me the judgment of the trial court.
Complaint petition.
Do you have the judgment of the trial court?
Lordship, can I take your Lordship to para 13 at page 31? His cross-examination. That is.
I am asking something for your benefit. You don't
got
answer that. Show me the judgment by which you have been convicted.
Lordship.
At least in the judgment top, it name would be written.
Lordship.
You are not helping yourself. That's the whole difficulty.
Lordship, this is a copy of them.
Judgment.
Judgment.
Yes, Kashinath Sahu. I will have to stay.
Let it come next week. I will
Just
satisfy.
see your name.
My lord, judgment
You
is-
yourself
that's
have written
yes.
Kashinath Sahu.
My lord.
Check was issued to Surya Kashinath Sahu. And in the
Hello, one more chance, my lord.
you yourself say I.
My lord,
Kakinatha out.
I will verify the record, my lord. Let it come next
Check
week
what
any day.
Surya Kakinatha out.
Any day, my lord, let it come next week.
Office cross examination.
Let it come next week, any day. my
Okay,
lord.
next week, next
My
week.
lord.
Next week. File, get the complaint. Did you follow what I'm trying to say? Tell. I just examine that because the check is written Surya Kakinatha. So that has to be seen. Yes.
Doctor, I have also prayed for a stay of deposit.
Next
No,
Next
one more chance, no, my lord.
next week, nothing will happen.
But
What
in
happened?
the event, the learned court below, even we raised the judgment of Jambu Bhandari, the court did not take learned.
Next
court
week
below.
I'll take it up because you file a incomplete petition. Yes.
23.
Next week there, na? Next week, don't forget. Yes.
Okay.
Yes.
23.
Yes. 23.
Lord, pardon your lordship, item 16. Passover item.
Yes.
23.
Yes. 23.
Hello, here the petitioner has challenged the interim order and why the execution order passed by the JMFC and Bhubaneswar in the execution case 19/2014.
None appears for the petitioner adjourned in the interest of justice. Yes.
24.
May I please your lordship? My lord, petitioner challenge the impugned order under Annex 3, running page 23, order taking cognizance by learned SDJM Nuapada in a complaint case. My lord, taking cognizance under section 318, 296, 351 subsection
Yes.
3 of a BNS read with section 65 of IT Act. My lord, the petitioners are the chairman of NSC Nuapada and executive officer of NSC Nuapada. The opposite party number 2 submitted a tender which was rejected due to single tender. And that action may be a civil consequences, but she has given a criminal color.
Show me the complaint.
My lord, complaint under Annex 1.
Facts.
The description of our party, my lord, he himself.
Come to the facts.
Facts, my lord. Facts, my lord, page 13. That the complainant being a contractor, she dropped tender paper for the work extension of administrative building, sale counter and co-compost shed and other ancillary structure inside the shed at Nuapada NSC for estimated cost of 62,11,973. The tender was called by good office of the above two accused persons. Third, that there was another contractor, namely Rahul Bose, who also dropped the tender paper.
I'll issue notice, sir. Just see. Because you have scolded them and all these things.
He alleged, my lord. My lord, it is also the cognizance taken in violation of a provision of section 223 of a BNS Act. My lord, which provides that opportunity of hearing to the.
Yes, yes. I'll issue notice, huh? Issue notice to opposite party number. Returnable. Yes.
25.
My lord, I stay further proceeding, my lord.
So you move up to this, no? Okay.
My lord, oblige your lord.
Yes.
25.
Yes.
Petitioner praying for a modification of order dated 5/9/2024 passed by the Lord Additional Third Additional Session Judge Bhubaneswar in BLPL number 1792/2024 in connection with the airfield PS case number 236/2024 corresponding to city case number 3744/2024 pending in the court of the JMFC 1 Bhubaneswar, my lord. My lord, kindly on.
Where is that order? Which page?
Annexure 1, my lord.
Annexure 1.
Yes, my lord.
You are agreed by some condition?
Yes, my lord.
Which condition?
He shall not commit a similar type of offense while on bail. Second condition, my lord, he shall not offer threat or inducement to the informant and other witnesses.
What is wrong in it? Why this condition should go?
My lord, in that case, my lord, petitioner filed an affidavit. Annexure 3 is the affidavit, my lord. Kindly.
Which condition is hurting you?
My lord, kindly see Annexure 3 on second para. that the fact is that due to extreme anger and fall for head line, I fell down and accordingly submitted a injury on my head. Succumbed injury on my head. Thereafter, due to anger, so also emotionally, in order to harass my husband, lodged a affair against my husband.
What do you want to show me? Tell me.
My lord, after getting bail, petitioner in mailing my authority for which I lost filed an affair.
I can't pass an injunction order in this proceeding that he should not file any case against you. If you commit anything, he'll file. If you don't commit, he'll not file. How can I pass an injunction order? And the condition for which you have come here, the condition is you shall not commit similar kind of offense. This is a common condition.
No matter.
I want that you will commit. I give a permission to you.
Second condition, my lord.
Which condition? He shall not offer threat or inducement to the informant and other witnesses. I'll say that you do it.
No, my lord.
Then?
Falsely, petitioner no to file an affair for again.
She might informant might lodge a FIR against him.
Might, maybe, or all this thing, and I will pass an injunction order here.
On apprehension.
Apprehension, on the basis of apprehension, no order can be passed. If anything is filed against you, then you tell that time. Wrongly filed or rightly filed, whatever. That time you have a cause of action to challenge. Today I can't prevent the opposite party by way of an injunction that you shouldn't file any case. Okay, or you have anything to say?
No.
Tell me if you have anything to say.
No, my lord.
He's not able to, I think, convey what exactly you want. Modify the order dated 5/9/2024. Where is 5/9/24?
924 page.
Is the first one.
Page 9.
Answer one, my lord.
21 page 11.
Page 12.
Oh, he is asking for modification of the conditions.
That
The conditions can't be modified.
apprehending
Just
that
general conditions.
he might be implicated in
Yes. Right on. The petitioner is seeking modification of the bail condition. Modification of the condition enumerated in order dated 5/9/2024, passed by the third additional session judge Bhubaneswar in while admitting him on bail. Admitting on bail. I have perused the conditions. The conditions are not prejudicial to him. The only the trial court has only restrained the petitioner from not inducing, not offering threat or inducement to the informant and other witnesses. This condition is a general condition, so I'm not inclined to take it. Yes.
27 to 30 withdrawal.
Yes, withdraw. 27 to 30 withdraw. Yes.
31.
2016.
May it please your lord.
Yes, sir.
Petitioner is a widow. Her husband was murdered. Trial is going on. Trial has been concluded. Your lordship will kindly see annexure 1. Order passed on 27/9/23.
What are you seeking here?
I am seeking that the trial be completed as soon as possible. Because this honorable court directed.
When was the FIR registered?
That very day.
2020.
Yes,
302.
My lord.
How many witnesses are there?
All witnesses have been examined. They have given a closure memo that will not examine any further witness.
Then why are you waiting?
Then, yes. The question is this honorable court directed for further investigation in respect to one part only. That is not being completed by the city crime branch.
Not completed by?
Crime branch. Your lordship will kindly see the prayer. They are not submitting the final report. The police has submitted panel of examination, cross-examination.
Everything is over. Everything is over.
That is the problem.
Just check it out. What is the stage? What is the stage?
Yes, sir.
Why the
He wants completion of the trial. He wants to see that the accused are.
I understand it. But at whose instance this petition was filed?
Another son of the petitioner. The son of the deceased. My son.
Yeah, Jagdish. Jagdish has filed.
Yes.
Because of this petition only it's getting delayed. What to do?
No. Let them complete the investigation directed by this court.
Sir, this order was passed in September 23. September 23. Just check it up. Pursuant to the State Council to obtain instruction regarding the status of the investigation pursuant to the order dated 27/9/2023 passed by the court in CRLMP number 1472 of 2020.
I have also represented to the additional DG crime branch that why don't you complete it?
Then let us see this. Yes. Get the status, huh? Okay.
May I kindly fix it?
Fix it. Date will be fixed. Don't worry. Yes.
Before vacation.
Yes. Let us see.
32.
May I please know?
January when was it? Last. Yes.
Petitioner, the advocate of this honorable court, the other co-accused are also advocate. Before your lordship, what has happened? Biplab Bahali, one of the co-accused, has gone to electrical department asking the SDO as to why payment made in digital mode has not been adjusted. So there is a skirmish between Biplab Bahali and the SDO, for which I first lost the information before the Commissioner of Police, Deputy Commissioner of Police, and CESU authorities, my lord. If your lordship sees, my complaint is at 7:55, dated 26/11/2019. The fight is between Biplab Bahali and the SDO, because I had gone to asking why the payment made by me digitally has not been adjusted. Then there was a skirmishes, they abused each other, my lord. So when there are 6 to 7 electrical people, so Biplab Bahali asked his associates. His associate is one of them, before your lordship, Kolingo Kesari and Bomkesh Tripathi.
He is the associate of Mr. Bahali.
Biplab Bahali's associate, my lord. So one of the associates.
Kolingo Kesari is the associate of Biplab.
And a regular practitioner. And Bomkesh Tripathi also. You also must have heard that name. Bomkesh Tripathi also.
I'll issue notice of the lawyers. Will issue notice.
No, if he comes, my lord, there will. Well, 341, 342, all these are minor offences. Compromise can be made, my lord.
That's what I'm saying. I issue notice. Let us see.
Proceeding,
I'll say. Small offense.
Very small offense.
Lawyers are involved. Yes. Issue notice to opposite party, returnable within 2 weeks or 3 weeks. In the meantime, and it's better that in these kind of cases you stay the proceeding, let it go for a longer time. Everybody will forget. That's the best way of doing it.
Come before your lordship for a compromise, my lord. Because notice, let the notice
go. For the proceeding, for the proceeding in which you the same. Where is the IA? IA also you have not filed.
IA file kar no?
What kind of stay then? You have not filed stay application. I think he.
Let it come tomorrow, my lord.
He doesn't want stay. You are insisting.
After all, he is a lawyer, my lord. That's why.
In the oral prayer, I'll make
yes.
The oral prayer of Mr. Salma. Tell me the particulars of the proceeding.
Yes.
At least.
OPS is no.
GR case number 2379.
Write it and give it. Write it. Good miscase of. You.
You're not saying pass order. I'll file this.
No. What I'll do is put it tomorrow.
Yes.
File it. Why unnecessary?
So I'll bring that miscase before your lordship.
Yes.
If you file it, it will not be tagged.
Huh? I file.
No.
I file.
Okay. I'll file it in due course.
Give the particulars.
Yes, okay. Pending the.
3.
Please, your lordship. And the petitioner has challenged the order of the learned.
Don't stay, it lead to strike also. Yes. It don't stay, it may lead to strike. Better than.
No more strikes.
Yeah.
Wait, please, Your Lordship.
Yes.
Madam, the petitioner here has challenged the order of learned JMFC, whereby the petitioner has been arraigned as an accused after 3 of the 7 charge sheeted witnesses have been examined, my lord. He was not charge sheeted. He was not charge was not framed against him. After 3 witnesses were examined, he was and prosecution filed an application for addition of this petitioner as an accused under section 319, and the learned JMFC allowed that petition, my lord. However, my lord, the law on the point whether at what stage an accused maybe I did, and what are the principles that says that it cannot be done in a casual and cavalier manner, my lord.
Yes, that's right.
The evidence that is required to be strong and cogent, that is more than that is required at the stage of framing of charge, but less than that is required for conviction, my lord. In this case, my lord, 3 of the 3 persons have been have deposed till date, my lord. They had not stated the same at 161. In 161 statement, they had stated against the present petitioner. The present petitioner was trying to pacify the other persons who were creating the nuisance, my lord. In the deposition, only one, PW1 states that all the accused persons assaulted him. In the FIR, he has stated that they merely quarreled. And also, the injury report has not been exhibited.
To what extent this witness was cross-examined?
He was cross-examined, my lord. I have annexed the.
Regarding that, he was trying to pacify. The departure is in 161 statement. He has said that he was trying to pacify. And whereas in the deposition he says that no, he has participated. That's the departure. And to that extent, what is the cross-examination?
Since this present petitioner was not there, no cross-examination on that extent.
No, the evidence might have come on record. Therefore, 319.
My lord.
What are the evidences of those 3 witnesses? Show me.
My lord.
Whether those 3 witnesses have said anything against you.
Annex of 4 series starts at page number 22, my lord. That is the examination chief of the PW1, my lord.
Yes. What is your name?
My name is Ratikanta Sahu.
Yes.
My lord. I'm starting from the 2nd paragraph, my lord.
Yes.
On dated 15/7, as per the direction of Tahsildar, I along with Tahsildar Rabindra Kumar Sabat, RI.
See the middle of the paragraph. At that time, 4 persons, namely Ratikanta Sahu, Bipin, Jagan, and another 1 person released near
us.
Your presence is there.
My lord. Listening the noise of quarrel, that is the examination, my lord. Then the cross-examination, my lord.
And then also started assaulting me. So. Listening to the noise of quarrel.
My lord, may find at page number 23 also. Only the OPD ticket has been marked as X. It has not been exhibited, my lord. It has been marked as X. Also, no injury report.
Oh, those things are on merit. I'm only interested to know what are the evidence which has come against me.
That is the only evidence, my lord. That's 4 persons were there, 4 persons.
That your name is very specifically taken.
Taken very specifically. There was another accused, another injured, my lord. As for the FIR, 2 persons, Utshav Deuri and this.
You might have injured only 1 person.
No, my lord.
The other person might not have been injured by you.
At least the other person is an eyewitness to the occurrence. Because he is PW3, my lord.
Yeah.
PW3. That is just page number 27, my lord. He says that only the accused persons, only 2 persons have been charge sheeted. Allegation was that 4 persons came. He says that only the accused persons, that is 2 persons, Bipin Bihari Das and Jagan, my lord. Page note 27, my lord. We followed the truck near Porua Khojo. 1 truck was present on the side of the village road of Porua Khojo. We rushed to the said truck and found that the driver and helper of the said truck left away by parking the said truck. Tahsildar directed Dinesh Kumar Rautra and me to present near the said truck, and our remaining official staff moved to follow the second truck. The accused persons assaulted. The accused persons are only 2 persons, Bipin Bihari Das and the Jagan. No mention of that unknown 4th person as well as the present petitioner, my lord.
But the only PW1 has said.
PW1, that is also omnibus allegation.
What do you say? There are 3 witnesses examined.
It's a lordship.
All the witnesses in 161 statement have said nothing against him. And whereas in the deposition, one of the witness, one of the injured, says that he was there. And whereas the 2 other witnesses says no. What is the position? 319. He has been summoned.
But 319 specifically states that any stage of trial, if any.
Stage is not important.
Yes, sir.
The quality of evidence.
Quality of evidence.
See, 2 witnesses not supporting, not taken the name at all.
But the
One of them is injured. One of them is injured. He say no. He was not there.
The other injured has stated his name
Yes.
specifically.
Reply. Let him file reply. Because one of the witnesses is taking name, the other two are not taking, then what will be the trustworthiness of that witness? Yes. And the same witness in the 161 statement says otherwise.
Has not
Get the
stated-
161 statement. Have you crossed he was not there.
I was
The
not
other
there, so I
accused might
cannot
not have
cross him.
cross-examined. That's another problem. Yes. We'll see. Yes.
34.
My IF stay.
No, I can't stay the trial like this because the other accused person are also there. Third date take me for third date. Yes.
My presence, my lord, the order that because someone is being issued to me, the NBW, they will issue NBW, my lord.
307.
My lord.
307.
My lord.
So you would get the bail what?
No, bail. I'm on bail, my lord.
Oh.
Now, the pursuant to this order, someone is being issued to me. If I do not, if I am not present during the trial, then NBW will be issued to me.
No, you go. What is the problem?
And so that is a very fact of the case, my lord. That,
No. You have to participate. In any case, you are there.
well, at least this
Yes.
particular order, my lord. Only this
Because
order.
I am only trying to examine. There is a small gap,
Right.
but not that you are innocent. You are there in the place in the place of occurrence. You are there, very much there.
My
Then you go and you are on bail. If you are not bail, you are on bail. Then tell me. I'll make.
I'm on bail, my lord. Trial
Then
may
you
go.
bail won't
My-
appear.
I'm not
No.
objecting
Yes.
to the
Yes.
proceedings of the trial.
Who knows if the evidence further goes? Some material may come
My lord,
against you.
trial may go, but I may not be asked to present.
No. You are
Because
not
that is,
VIP.
that is pending before your lordship, my lord.
307 Yes. Next.
34.
My lord, not 307, my lord. Not 307, my lord.
326 maybe.
No, my lord. Allegation.
What are the offences?
Offenses, my lord. 323, 341, 294.
Oh, it's all right. You go. What is the bill?
Well, but if
You
I
are not
will be-
are you a very a law and order problem would be there if you go? Are you a VIP? You can't go.
but that is before.
You are on bail. What is the ego issue? You have attacked someone.
No ego
because only because of some technicality is there. Therefore, you won't go and face the trial.
No
and if
ego-
you are not on bail, you tell me. I'll grant you bail.
Man, no ego
You are
issue.
entitled to bail.
Man,
That's all.
the validity of that order
Yes,
is
next,
before your
next,
lordship, my
next,
lord.
next.
And the very validity of that order, and then fix a short date, my lord.
Yes. 34. Yes.
34 may I please, your lordship?
Yes, sir.
Lordship, here is my lord, prosecution filed a closure memo without examining the IO of the case, my lord. In this case, the IO has filed the charge sheet, my lord. And after that, the counsel of the defense, my lord, filed a 233 CRPC petition before the London court below to examine the IO, my lord.
Yes.
That, my lord, the
Who are
input.
you?
I am the, my lord, accused person, my lord. One of the accused, my lord.
Yes.
Only imputed order is, my lord, Annex 4, my lord.
4.
Annex 4, my lord.
Yes.
Page 33, 32 and 33, my lord.
You are one of the accused.
Yes, my lord.
Rajendra Singh. Yes.
Yes, my lord.
May I please, Your Lord?
The London court below, my lord, stated that, my lord, the present IO has not covered the substantial period of investigation, my lord. In this case, my lord, total 4 IOs are there, my lord.
Who are you to insist the prosecution to?
My lord, I am not insisting, my lord.
That's where the application
No,
is.
no,
They don't
There
examine.
is, my lord.
They'll face it.
Yes.
But the fair trial is not concluded. If the
See,
IO is not
you-
examining this
you
matter, my
take
lord.
advantage of that.
No,
But
my lord.
you can't
What
force the
happened, my lord?
prosecution.
In this case, my lord, the present IO took charges from the previous IO, and he investigation the matter around 10 months, my lord. After 10 months, he filed the charge sheet, my lord. And during his
If the prosecution chooses not to examine the IO, the benefit directly flows to you. Why should you insist that no, the IO should come?
there is certain question, my lord. I want to ask to my lord. The present IO conducted the TI parade, my lord, and the present IO remand all the accused person from another case to this case, my lord. That is the problem, my lord. He conducted the TI parade, my lord.
You can lead your own defense evidence.
Yes.
Who stops you?
And without examining, my lord, fair trial cannot be concluded, my lord.
My Lord, kind of
Only
paragraph
if
3
the
and
lordship.
of the
Yes.
ordinance. There are 4, may I read you?
On the other hand, learned additional PP submitted that the present petition is not maintainable in the eye of law and it is filed.
The substantial part of the investigation, there are 3 IOs.
4 IOs.
4 IOs.
4 IOs.
And
They have examined 3 IOs.
Yes.
And this gentleman has only filed the charge sheet.
Not
That's
filed,
what-
my lord.
That's what is the finding.
No, my lord. My lord, I after verified the my lord, case record,
But it is a prerogative of prosecution. You can't insist them.
only one date may be fixed, my lord. I will examine him and she is
No,
now
that's
posted.
right, but
she is now
how-
posted on
Under
Sundargarh.
what provision I can do it? If the prosecution wants, do you have any judgment that you can insist?
I
That
found some
X
judgment
witness
regarding.
has to be examined by the prosecution.
My lord, I found some judgment regarding fair trial, my lord. And
Fair trial is there. This is,
without examiner, how can
if
I
it
fair
is prejudicial to you, then only. It is prejudicial, it's not prejudicial to you.
It's
I don't think you have a.
And it was also written, my lordship, in the present case, the magistrate who was conducted TI parade also has been examined in PW 20.
but prayer,
And,
I made the prayer before.
And also, my lordship, she
I was
only
present.
submitted the charge sheet, nothing else, my lordship.
And just see, the trial court has rightly relied upon Sundarlal.
Yes.
That's what I was saying. It will not preclude you to lead the defense evidence.
Yes.
You can summon him as a witness. That's the Sundarlal.
One.
Petition is agreed by the order dated 8/11/2024, whereby his application under section 233 CRPC praying for seeking direction to the prosecution to examine Mrs. Bangi, SI of police, to be examined has been turned down. The trial court has rejected the application on the ground that out of 4 IOs, 3 IOs, those who have conducted the investigation have been examined by the prosecution. However, the 3rd IO, that is Mrs. Pangi, Ms. Pangi, who has only submitted the charge sheet, has not been examined, and the prosecution is not willing to examine the said. Therefore, the application moved by the petitioner to call the said IO to the witness box has been turned down. Has been turned down by the trial court in the MP note. The trial court had relied upon the judgment of the Supreme Court reported in 2004 SEC online SC Supreme Court 112 Sundarlal versus State of Uttar Pradesh. The law in this regard is well settled that the accused cannot insist the prosecution to produce any witness of his choice. Rather, it is open for the accused to lead defense evidence by recalling any witnesses to substantiate his case on defense. Therefore, I am not inclined to entertain this petition as there is no infirmity in the impugn order. However, dismissal of this petition shall not preclude the petitioner to lead defense evidence to substantiate his case on defense.
35 compromise party present.
I'll just come and yes.
Three 341 to 94, 323, 379.
Let us see the allegation.
My lordship.
Investigation is on.
Yes, my lord.
And it belongs to page number 13. The FIR.
1-3. Okay.
Yes.
Yes.
Mahasaya, may I read? Second paragraph. Mahasaya, ଗାଡିରେ ସମସ୍ତ କାଗଜ ପତ୍ର ଓ ମରମର ଚାଲାଣ ଥାଇ ମଧ୍ୟ ରାତି 3ଟା ପରେ ତହସିଲଦାର ବେତନଟି ଆହ୍ୱାନର 2 ଜଣ ଗୁଣ୍ଡା ଶ୍ରେଣୀର ଯୁବକ ଓ ବାରିପଦା ଉପଜିଲ୍ଲାପାଳଙ୍କ ସହ ମିଶି ବିନା ଦୋଷରେ ମୋର ଗାଡିକୁ ଅଟକାଇ जघन्य घटना उपयुक्त तदंत कराई दर्शाई दंडविधान करागले आम्बे उपकृत हबो प्रकाश थाउ कि जे सरकारी ऑफिसर ओ गुंडा श्रेणी रो युवक मो मरम बोझई को गाड़ी समस्त कागज पत्र थिबाकू अटकाई थिबारु एवं श्री अभिजित महल सुदाम सोनसो मते बारंबार फोन जोगे तहसीलदार को द प्रेजेंट पिटिशनर मेल आसे कथाबार्ता कराई एवं कॉम्प्रोमाइज करी 1 लाख टंका तहसीलदार को देई चोरा व्यवसाय करबा पई का प्रभावित थिले तेणु मु मानसिक चापरे भाराक्रांत होई घटना घटिबा परे संगे संगे एतला न देई परी बालेश्वर and now they are coming for the compromise.
Who is the complainant?
Complainant.
Yes, your lordship, I am the complainant.
Where is Sitan? Come here.
The lordship,
Right to appreciate. I'll simply adjourn.
stay the further proceeding refer to the petitioner in between.
Yes, that's a better idea.
My lord.
Better idea than because the investigation is still going on.
Yes, ma'am.
Yes, my lordship.
You ask your client that at least he should drop charges against all of them.
Oh, yes, sir.
Okay, I'll just simply adjourn after
Stay, my lord.
after a week.
Stay for the post.
No. So investigation is going on. I'll stay.
Yes, yes.
What is this? Yes.
Next week, my lord.
Yes.
36.
What's my plea, your lordship? Arising out of complaint petition, my lord, the FIR was lodged. But the managing director of the company against the account director, my lord. The account is held in the name of my lord, company represents which managing director.
Yes.
My lord, the money has been transferred to account any of the account, my lord, that has been OTP and transaction is it was been go to the my lord, the managing director. Now, lordship, the allegation.
Who are you?
I'm the director of the company, my lord. Lordship, I can only for a my lord that page 20, the 10 line, my lord. The what they have said,
Page 20.
Page 20, 10 line, 21/1/2019 by check number so and so, rupees so and so. Let's see for a moment, my lord, account statement, page 87. There is a no check number, my lord.
Let's complete the sentence.
Yes, yes, my lord.
Page 20, you have shown what?
Yes, 21/1/2019 by check number 149453 for rupees 10 lakh.
All the checks.
Yes, my lord. Let's see that 27/2/2019 by check number 780,667 of 5 lakhs. That is a lordship may mention it, my lord. And other checks are there. Lordship, for only one document, my lord, the account statement, page 87. For a moment, my lord. 87. Running page 87. Let's see, may below 21/1/2019. This said check never been utilized, my lord. Then neither I am withdrawing the money, but your lordship false allegation that has been FIR has been lodged.
The checks were given to the company.
Company, Millers. Company without sign of the without
one of the directors.
Yes, without sign of the managing director, let's see, money cannot be withdrawn. And
I don't know what is the arrangement.
And Millard, lordship,
company, what is the arrangement?
Company as per the lordship knows the article of association that has been the company.
Maybe the arrangement may be one of the directors.
And why laws and FIR, Millard? There are two directors. Only managing director and I am.
Right.
Yes. And Millard, as per the why they are Millard laws and FIR by revenge me, Millard. Page 101, my lord. I have lost the FIR because they misutilized something, my lord. The key password
What is the transaction that has answered?
Transaction, my lord. The transaction is along with the account statement I have given, my lord.
24 lakhs.
24 lakhs. But it was, my lord, all the checks. It has been without sign of the managing director and director joint signature. Money cannot be drained, my lord. And so far as this allegation is, I have drawn lordship attention for page 87 and 92. That is the check number mentioned in the complaint petition. That is, my lord, is a fraud. That is no check has been utilized on that number, my lord.
The complainant is also a director.
Admitted director. Director, but in lordship that I am not withdrawn, my lords. I am not withdrawn. Lordship, all the facts, lordship 87 and 92 is very clear, my lord. Lordship, I have not check as we withdrawn, my lordship 21/1/2019. As for the allegation of the FIR, that check has not been utilized.
Between two directors.
Two directors.
I'll just issue notice, let us see.
Yes.
Then work it out.
Yes, sir.
Otherwise, it's not a case for passing. I'll just
or your lordship, one thing I pray,
well,
all the documents are probably for the investigating officer.
But at this stage, can I appreciate all these things?
Lordship.
I can't appreciate all this.
Lordship.
So therefore, I'll just issue notice. Let us see. Bring him.
Lordship.
If we can send it to mediation, what is the amount?
Amount, 24 lakhs 50,000.
24 lakhs. 50-50 partner, you and
Yes.
equal partner.
Lordship.
You will you deposit something? I'll stay the proceeding.
Lordship, the investigation is on, my lords.
Also, investigation.
Yes,
Or simply issue notice.
Yes, no.
To
And my lords, the no coercive action because the till date it was a no notice, nothing has been issued to me, my lords. Since
So that
2023.
if, you move application immediately if anything happens. I'll give intelligence.
Lordship. Okay. Because I'll also
Take out notice. Take out notice.
Yes.
If anything happens, move application or mention.
I have already interim application I have
Yes,
filed, my lords.
you mention it. I'll take it. Yes,
Lordship.
grateful. But try and settle it out. You
Yes,
have to
Lordship,
pay the money. That's all.
Because the
It's a matter of money now. Nothing.
Lordship, there's a lordship.
And why don't you deposit 5 lakh rupees? No course you. In any case, 50% partner, 24 lakhs. You have to pay 12 lakhs at least. You deposit 5 lakhs and pass that off.
Let me appear, my lordship will sort it out. Lordship is in presence, so lordship will sort it out.
We'll see. Great.
Wait, prisoners. My lord has already was pleased to hear the matter with regards to the co-accused, Professor Kumar Das. And I think after hearing both the sides, my lord was pleased to close the case. Here, my lord,
This is that matter lordship permits, my lord. The lordship disposed the matter on the basis of instruction and obtained. My lord, this particular case comes for the first time, my lords. The department deserve a particular.
There are two accused, Prabhat Kumar and.
No, if a lordship, one minute. If a lordship turn to page 62, my lords.
62.
Not to refresh your lordship, many my lords. 2003 is the starting date, my lords. Lordship next on to page 66, my lords. That's order that which raised your lordship eyebrows, my lords. Page 66, my lords. FRT. And my lord, then the last order is.
This matter, I understand.
Lordship got the points.
Not received.
May I suggest one thing, my lord? This is coming for the first time, my lord. Let me.
I'll say the
let me. No, let them move that application for. Lord, I will come back to your lordship.
After 50 adjournment without issuing notice to the.
No, my lord. I understand them, but at the same time, the department deserve a notice, my lord. Just give me 2-3 days time, I'll come back to your lordship.
Okay, I am giving you opportunity. I'll issue notice and stay the proceeding and let us see. This is a case where apparent case. Apparent case. And no protest petition filed, no protest petition filed. Thereafter, all of a sudden, one day, Cognizance is taken. Very. You see, the trial court should have seen the proceeding. Notice was also not issued.
And those clients, they therefore is Mr. Bharat because picture.
Agreed.
No, my lord, here, in peculiarity of the case is most
Sir is saying that the
no, my lord,
trial court is designed in such a fashion to
he is by elder brother.
To enrich him, Lord. I agree with him.
That's what.
But here is the key peculiarity of the case is entire case by 120 will agree. 29, 30, 31, 35, 40. 5 cases were registered against same accused persons for the same set of works.
I know. Besides that point, this is apparent on the record. 2003.
And one case he accepted the final report. Court accepted the final report, say it's correct, absolutely correct. So case is closed. But with regards to 29, 30, 31, 40 notices.
I'll come back to that.
Why to delay it? In any case, I'll have to quash it.
No,
Why to delay it?
But for their convenience.
Protocol demands that there.
Yes, I will issue notice, but I'll keep it this side of the vacation so that I can finish it up. That's what I'm issue notice for the proceeding state and put it on 23.
20th minutes?
23. Third, 23rd.
Stay abandoned.
Stay, yes.
No, if it is on 23, why stay?
11 cases posted to 11. And so
nothing will happen.
I draw the attention.
Because earlier case,
the problem is
I draw the attention of the local lawyer that the case filed on behalf of Ashok Das has already been closed. Judgment is reserved, but his court didn't accept it.
No, the 5 cases are. Anyway, I'll come back to that.
No, with regards to present,
but the stay should not be impetus for you to seek adjournment here. At least close it.
No, my lord. I will not take any adjournment.
Okay.
It's because my lord, you will see the age 90, 91.
I know, I've seen that day. Yes. 38.
May please, madam. Yeah, madam, it is a Belgium case, madam.
Yes, madam.
Granted on
And,
8/9/2023 and NBW was issued on 21st/10/2020.
Okay, 500. Yes. Next. 39.
Oblate.
Bill was granted on
2110, my lord, 24, no? 21, NBW.
21/10/2024.
Oblate.
Yes. Yes,
Bill was granted on 13/2/2024 and NBW was issued on 5/7/2024.
my lord. Yes, 500. Yes. 40. Okay.
40 was my lordship, bill was granted on 26/11/2021 and NBW was issued on 23/9/2024.
700. 70 each. 70 each color. Zero.
41, my lordship.
And
Bill was granted on 26/2006.
my lord, 1 minute. I'm in 1 minute. One minute. Right. The cost will do, no? Yes.
My lord, 40, my lord.
40. Yes.
The date.
Yes. 40.
40.
Yes.
Earlier occasion he was also in bail, my lord.
Okay, 500. 500 each. Pay 500 each and finish it.
41, my lordship, bail was granted on 26/9/2016 and NBW was issued on 17/7/2020.
Okay, 500. Yes. Next. 42.
May please, your lordship.
कितने बिल लगा था भाई?
Offense under section 21 B of NDPS Act, my lord. Earlier, this petition was
Yes.
Granted bail, there is no article will be released on there. But the, if, on verification matter, the current transfer found that by another, case is there. In similar way.
What is the status of that case?
17,
No.
yes, 17.
already he has been released on bail by this honorable court under Annex 3, my lord.
Annex 3.
My lord.
What is the recovery in that case?
My lord, 28 gram of heroin, my lord.
You file affidavit. File affidavit. How many cases are there against you?
My
File
lord,
affidavit.
only one case has.
No, you file affidavit and tell the status of that trial of that case. Yes, next. 3.
CD is not there. Yes, submit.
All for CD.
Documents.
All for CD. Yes. Next. 44. 4. Yes.
Please, Lord.
Yes.
Offense under section 302 minutes. First time it has been related city.
Custody since
There. Right now.
it is there.
16/5/23 minutes.
Huh?
16/5/23. 16
523.
minutes.
Okay. Yes.
In this case, my lord, some of the co-accused have been released on bail.
Yes. What is the role of this Prakash Kotwa? Yes.
I prefer an adjournment, my lords.
Okay. Urgent.
Let it come along with another BL appeal 5507 of 20.
Yes. Next. 45. 55.
00234 IPS, my lord. Custody 18/1/23, my lord.
18/1/23,
my lord. Charge sheet submitted on 33/23, my lord. An allegation, fact of the case that one marriage ceremony is going on in the village, my lord. And someone found that someone entered in naked condition in the house of one Kusun Munda, my lord. Thereafter, some villagers are caught him, tied in a village, my lord. So some person assaulted by means and fist broken, and the present prisoner, who is the brother-in-law of that house, my lord, he came at that time and give one goita, my lord. Yes.
Yes. And he died.
He died.
He next day found that.
बंदा अवस्था पे मरिगला तो मारली छाड़ सकाळ मरी
Custody since around
Munda.
2 hours, 2 years.
What are the allegations against him?
this my lord this is ଗୋଟେ ଜୋତାର ଗୋଟେ ଗୋଇଠା ତାକୁ ମାଲ ବାନ୍ଧି ଦେଲେ ଲଙ୍ଗଳାଇ ତାଙ୍କର ଭିତରେ ପଶିଗଲା so they have tied that person and assaulted by kick and fist blows. One person is assaulted by means of lathi. And this petitioner is assaulted by means of gave a kick by wearing a sword.
Oh, show me.
That is
what is the position of PW1? Who is the PW1?
Nobody supported.
So nobody supported, my lord. Who said that, my lord? 164.
164 they have stated. They have not.
So what to do?
जे कहला जोता मारी थी से तार एविडेंस
none of the witnesses supported you.
Yes.
Then what?
164 ହେଇଥିଲା they have examined PW 4 PW 7
कार 164 ହେଇଥିଲା
ଆଜ୍ଞା ମୁଁ ହେଇଥିଲା ଆଜ୍ଞା
PW
ନା ମୁଣ୍ଡା
ହଁ
Punna Munda.
PW4.
He's PW4.
Kunna Munda.
And Chandan Mahakud.
He must be the eyewitness. Kunna Munda and
PW3, Chandan Mahakud.
एक मिनट Kunna Munda and
Chandan Mahakud.
huh?
Chandan Mahakud, PW3.
Chandan.
And Kesav Chandra Mahakud, PW7.
So Kunna Munda is Chandan is PW3. PW3 and Kunna
PW4.
PW4.
PW7.
And PW7, huh? PW7 is
Kesav Chandra Mahakud.
Kesav. Then nothing is there. Yes, right of petitioner is accused in FIR number 24. The allegation against the petitioner is shown. Bill application is reported. And petitioner is in custody since 18/1/2023. The incident alleged to have been witnessed by 3 witnesses, namely one Punna Munda, Chandan, and one Kesav. Statement of these witnesses were recorded during the investigation under section 164 CRPC. They have clearly implicated the present petition. However, when they deposed, when they were brought to the witness as PW4, 3, and 7, they have wriggled out of their earlier statement and did not support the prosecution. Therefore, the said witnesses have been declared hostile under section 154 CRPC. The state witnesses have also sustained prolonged cross-examination by the prosecutor. However, nothing could be elucidated against the condemned.
Krishna Munda confessed before the police. He got a confessional statement. Police Krishna Munda said that he along with his brothers are
brothers, but brother-in-law.
Brother kids coil and co-brother.
Mr. General and Counsel for the State submits that by pointing out the cross-examination of PW7 has pointed out that in the cross-examination by the cross-examination,
paragraph 4.
Paragraph?
25, page 20.
Page
25.
25. Working out para 4 of the examination and chief of the PW7 permitted that the said witnesses have implicated the co-accused persons. And implicated the accused person. Specifically implicated the accused person. But reading up for the para 4 but reading up for the aforementioned evidence makes it clear that no specific allegation is made against the present. In the FIR, the allegation against in the charge sheet dated in the particular is that he has given a kick blow to the deceased. Big blow to the except that nothing else is attributed to the petitioner. Petitioner is in custody since 18/1/2023, and the evidence, the vital witnesses have already been examined, and they have not supported the prosecution. Therefore, the petition is entitled for grant and bail according to the law. Yes.
46, I'm sorry, my lord, item 43, can it be passed?
Which one?
43.
Yes,
CD corporate. Yes, 47.
46.
46.
46 also CD is not.
Call for CD. Call for 47. 47.
One chapter. One chapter.
We go to yes.
8.
The lordships on behalf of learned counsel, Mr. S. Patnaik, I prefer an action. So that, yeah, so that, yes. On behalf of the petition. One capital line. Yes, sir. One capital line. 49. Yes. Prefer one capital. January, February, yes. May I please, Lord, sir? On request, sir? May I please, Lord, sir? Yes, sir, 50. Who does it? 44, did you see? Huh. 44 on request. Yes. I pray Marana, approve vacation. After vacation, you don't have a case. Try if you have a case, you can get no. This to come first time, come my lord. 302 method. 302. Already granted. Yes. 51. How less? You don't ask for pass out today. I'll be.
This case, total out 18 charges to witnesses. 32 witnesses are in exam. Appointment taken by not defending the bail petition also. And only 5 numbers of deposition are supplied in the brief. Remain out 8 numbers because of the not been sought. Lordship may say
You get the order witnesses. Huh?
and when you next
so far 13 witnesses have already been examined in the present case, and the deposition of 5 witnesses are only supplied placed on the record, and placed on the record. And talk about the petitioner takes an agreement to place on the record of the deposition of the remaining witness. Yes.
You are also allegation that the father-in-law sold SC to his son-in-law. It is not with me.
Call for city vote. Yes, sir.
Allowed by one Hon'Ble, then petitioners along with one Dilip Maji were arraigned as an accused in an offense summation 302-201-34 of the Indian Penal Code.
Yes.
Custody, petitioners are in custody since 19/9/2023. Charge sheet has been submitted.
Yes.
Against the present petitioner along with the co-accused. Madam?
Yes, this is the lordship.
The father.
Yes. Krishna Chandra Bhoi, what are the allegations against these people?
Against the present petitioner is that the father of the informant went to a village to witnessing the cultivation field on 14/9/2023. He did not return to his house. On 15/9/2023, the informant tried to contact with his father, but in vain. Subsequently, while he was searching to his father, he came to know that the present petitioner, along with another, took his father and committed murder and concealed the dead body in a muddy field. That was the allegation. Though the informant alleges that he was hard, but he has not disclosed the name of from whom he was hard.
What are the recovery?
EWA is the Brahmananda Das is the eyewitness to the occurrence of Sheikh. He is clearly stated in every present petitioner.
Who filed the 53.
This is a 53 lordship.
Examination is totally static.
Sorry, lordship. One password lordship, 53 is filed. One password. 54.
May I please? Initially 457 and 380 the FIR was filed, and on the last occasion, Lordship has asked me about the antecedent part.
How many cases?
4 case I have given the affidavit.
Affidavit.
Again. I have given the affidavit along with all the
Sorry, in one case you 300.
No, other cases remanded. कंप्यूटर नहीं जाइछनी कोन आ पाखरु सीजर लिस्ट रे हला रिकवरी ऑफ 2 सीसीटीवी कैमरा फ्रॉम द प्रेजेंट पिटिशनर
Okay.
page 12.
The other accused persons got bail.
Yes, they are released from the Senate court only because of antecedent part. This petitioner before my lordship I have given all the bail orders.
You were in custody in which case?
Custody in my lord. First I was arrested in custody in 2234 of 2023. City case number.
City case number
2234 of 2023.
23.
Thereafter remanded in 2603, 2688 and 2589 of 23.
City case number 23.
Remanded.
Remanded in 23.
2603.
2603.
2688.
2688.
Thereafter 2589.
2589.
Of 23.
23.
And this present case.
And 23. All are 23.
All are 23. And this present case also.
Present case number? City case.
Present case city is 929 of 24.
So you have 1, 2, 3, 4, 5 cases total.
Total.
25.
Custody custody since 27/3/2024.
Yes.
This should be the one statement is clearly stated that present petitioner will seize each of the.
Data CCTV camera see je apa.
But the problem is in one case these are arrested and remanded in all again. Many cases are false cases. You are not able to solve the cases and one accused you find and remand him next morning.
FR सब unknown FR जाते सब उधर remand
Okay. The petitioner will continue to 2024. This is the petitioner was arrested in one city case number 2234 of 2023. 2023 on arrested on
my lord 21/5 नहीं arrested डेट टा सही है जो डेट टा कहले आपण
हां नहीं अरे एटा रिमांड नहीं थियो ना तारागुर अरेस्ट थी
तारागुर अरेस्ट কিন্তু आपरे बेल ले जाई 24/5/2024 रे गला फास्ट बेल रे गला ए जो फास्ट केस टा 24/5/2024 में गई थी ना छटपट को भी
arrested in city case number 27 while he was in custody and on the basis of his confession and the confession of the court, he has been taken in remand in as many as 3 cases, namely in city case number 2603 of 23, 2688 of 23, 2589 of 2023, besides the present case on taken on remand on 27/3/2024. In the first case, where he was arrested, that is in city case number 2234 of 2023, the petitioner has already been allowed of bail on 24/5/2020.
So also in other cases also on the same.
Equally, the other cases where he was taken on remand. The petitioner has already been allowed of bail.
Yes, on the same day, on 24/5.
On the same day, that is on 24/5/2024. But for the pendency of both the similar cases, the petitioner's bail application has been turned down in the present case. Hence, he has a progress call. Regarding to the nature of litigation, and the fact that the petitioner has already been enlarged on bail all the 3 similar cases he was entangled and also regarding to the fact that the petitioner record to implicate the present and that the petition on bail. Every Sunday, every Sunday, of course, agree. First, first and last Sunday. Every first and last Sunday of every week. For 6 weeks before. Okay.
Procedural indicate that charges has been submitted on under offense 457, 380 and adding section 390.
Sure, yes. Yes, 53. Yes, sir. Ready? Put it tomorrow, day after. Yes.
Kindly see your lordship's order dated 26/11.
Monday, if the matter will be listed on Monday.
Monday. Yes.
26/11/2024. Lordship's order.
Yes. Report has come.
When a report, no report was called for. Your lordship.
Direction to verify whether this case is covered with the judgment of reliance of Vipakas in the
Yes.
and the reverse must be clear and that's what.
Mhm.
I'm only clarifying the lordship. Yes, the reverse must clear in the state of the properties lordship in that case, your lordship with the accused prisoner staying inside in for 2.5 years lordship, the trial has been started. But here in the case, trial has been started. And the accused prisoner is started only for within 1 year.
No, 1.5 years.
That is the difference and
1.5 years and
I mean, in this case, no antecedents.
no antecedent.
Here also no.
I don't have any antecedent.
What is the result?
Hello?
And it is. If why is it also 420 kg ganja is the same control.
420 kg ganja, 7 motorcycles. On each motorcycle, 60 kg was there. That is the FIR.
What is this you're saying?
Lordship, Dheeraj Kumar and Shukla and the State of the Police Lordship that doesn't be Lordship.
Yes, there is responsible for he seems reliable.
Yes, Your Lordship. Verify whether that accused is same in clarifying that in that case, here in the Dheeraj case, the trial has been started and accused is inside for 2 and some odd months. Therefore, the
What is the recovery in those cases?
here in the present, so television. There is no position. Your Lordship.
What is the recovery?
Position.
Report is not clear. 92 kg. 92 kg. Yes. In this case,
My lord, in this case, total they have 420 kg, but on each motorcycle, 60 kg. There are 7, you lordship, I kindly got to page, my lord, page 12. Page 12. My lord, after 10 to 15 lines.
distinction between Dheeraj and Ravi Prakash is in Ravi Prakash 247 kilo recovered. And he was in custody for 3 years. And in Dheeraj 92 recovered in custody in for about 1 year or so. What is the case period? Dheeraj. And trial has not started yet.
Yes.
So therefore the Dheeraj Kumar they have granted.
My lord.
But here is a case where recovery is 400 something.
400.
And out of 38 cases, 10 witnesses have gone already in examination.
They have been town hostile.
They
And
have
no seizure. According to them, there was no seizure. And so far as myself is concerned, my lord, there are 5 to 6 motorcycles.
But what you show me that seizure, whether they are the seizure witness to be contraband? Yes. That's what I asked you. Who verified it? Whether they are the seizure witness to the contraband seizing?
Who is the reliance and last time my understanding is reliance one, two, and three. Not about original matter.
Yes.
Seizure. My lord, seizure, nothing was seized in my presence.
Kindly, last time also I asked very specific question. Come to an except two. Come to an except. You have not understood it. Come to an except two.
Yes, sir.
PW1.
Yes, your lordship.
Yes, see what is written. Nothing was seized in my presence.
Yes, your lordship.
I was not examined by the police. I put my signature on the paper marked as exhibits also. These are the exhibit relatable to the seizure of ganja or what? What are the seizure? That's what I'm asking. Whether seizure, they are the witnesses to the seizure of ganja.
Yes.
Let me know one password, let's say, I'll verify and see them.
That's what I'm asking to every time.
Yes, yes, sir.
And next witness, just see PW2.
Same thing.
What are these exhibits?
Yes, sir. I will specify, I will also give the details of the PW 1 and 2 and 3, your lordship.
Saturday.
Yes, your lordship.
I'll not adjourn the matter now.
Yes, your lordship.
And second one.
I'll just write that the prosecutor could not assist the court, therefore I'm granting bail. Simply I'll write it. I'll not wait for it. 5-6 days I have given only to verify this aspect. What are the, see, 1, 2, 3, 4, 5, 6, 7 dates. Only to verify this aspect, the exhibits which has been seized, they are the seizure witnesses, PW1 and 2. Whether these exhibits relate to the seizure of ganja or something else.
Yes, sir.
Yes.
Reflect in the order.
And 50, and another matter has been tagged.
Yes.
My second one is I have been arrested on the basis of the co-accused statement.
Oh, the same FIR.
Same FIR.
Yes.
56, my lord. But last time your lordship was pleased to almost, your lordship directed me to file an affidavit stating therein about my details of my
Police station.
station and other things, and I have filed it.
How many cases are there?
No case.
No.
Yes. You are in custody since?
My lord, I am in custody since 14/4/23.
14/4/24.
23.
23.
Yes.
Yes. What are the allegations? Let us see. Yes. 23. More than 1 year. Yes. What is the position? Trial position? 150 kg.
Yes.
151 kg. 991.
Trial has not been started.
Trial is yet to start.
Release the matter on 23rd. Because the witnesses, the matter was fixed for 13/12/2024, 16/12/2024, and 17/12/2024 for recording of evidences of
But
23.
non-examined.
Let us see. Today is December 2024. 13th, 16th, and 17th. I'll put it on 23rd. Let us.
My lord, last time your lordship was pleased to, your lordship may kindly see your lordship's order.
Yes.
And your lordship was pleased to direct me to file an affidavit.
I know, I have seen that.
Yes.
I've seen that. Wait, what are the witnesses they are producing?
When your lordship.
23rd.
23rd.
23rd, because after 17th only I can take it up.
Yes.
23rd. Yes, 23rd. Yes.
Oh, bless.
May it please your lordships. May it please your lordships.
Yes.
The petitioner has been arraigned as an accused in city case number 929 of 2024, and on the basis of FIR lodged by the informant.
Yes. What are the allegations?
This is the case, this is case identical to case item number 54, your lordship.
54. Yes.
How many cases are there against you?
At page 5 para 8, I have total four number of antecedents. as those of Amin Munda in item 54.
But finally, they mentioned the
Custody since?
I am in custody since 28th March 2024. Para 9, page 5.
Yes. In all other cases, you have been
Your
granted
Lordship's
bail?
in, I am appearing in Bail Appeal 9201, the sub item.
Huh?
And this is arising out of the same case that was at item number 54, Your Lordship. Your Lordship's granted bail to the co-accused person.
No,
And as
no.
per your last,
First concentrate on the first matter.
Your Lordships.
In this matter, you are on bail in all the cases?
Yes. I have given the BLAPL numbers and I have been granted bail on 4 July 2024 by
How many
the lawyer.
cases are there?
Total.
1, 2, 3, 4. 4 cases.
4 cases.
And he has been granted bail in
All the
1.
4 cases. I have given the BLAPL numbers.
He has 5 cases. In all
Yes.
the cases, he has been granted bail.
Yes.
You were taken into custody in which case?
I have been taken into custody in city case number 929 of 2024 arising out of Mangalpur PS case number 120 of 2024. And your lordship, in this case only one CCTV camera has been recovered from my possession.
Yes. Petitioner was taken into custody in relation to city case number 929 of 2024 corresponding to the question. While he was in custody, he appears to have given confessional statement. On the basis of his confessional statement and the confessional statement of the co-accused person, he has been taken in remand in the present case on 28/3/2024. Petitioner has in the paragraph 8 of the petition has mentioned that he has 4 cases registered against him. And all the 4 cases, has been, he has already been enlarged on bail, and bail. For ready reference, the para 8 of the petition is reproduced for him. Okay, reproduced for you. Counsel for the petitioner submits that while he was in custody, his confessional statement was obtained by the police, and on the basis of which he has been taken into remand in all the 4 cases, including the present case. He is already in custody for about from 28/3/2024. Bail and corridor and same. First and last Sunday, they have to appear before the PS. Yes.
Submit one thing, my lord. In this case,
So item, what is this?
Your Lordships, I completely stand on similar footing, except the seizure of 2 computer is from my possession. And Your Lordships, I have also arrested in connection with this case and taken on remand in 4 other cases, except that I have 1 more case, Your Lordships. I have filed an affidavit.
Where is that affidavit?
Yes. As per Your Lordship's direction, I filed an affidavit, Your Lordship. That is at flag.
Yes. How many cases are 1, 2, 3, 4, 5?
Your Lordship.
6 cases,
Your
including these 6 cases. You were taken into custody in this present case.
Your Lordship.
And the other cases are you are taken remand.
Your Lordships.
You arrested on
28/3/2024. 28/3/2024.
Same day.
Your Lordships.
You are co-accused, okay.
Your Lordships.
Petitioner is accused in so and so. Allegation is petitioner false. The petitioner was taken into custody on 28/3/2024 in the present case, and on the basis of his confession before the police, he has been remanded in 4 more cases. 1, 2, 3, 4, 5 more cases. The particulars of the cases in which he has been taken remand has been enumerated by the petitioner in his affidavit dated 26/11/2024. For ready reference, para 4.2 of the affidavit is reproduced here. Let go the Mr. Mahathir, let go for the state oppose
The extra has
the
been
bail.
seized from the present petitioner.
Bail oppose the bail as a recovery has been affected from the present petitioner in the present case. Two computer has been recovered from the petitioner. The petitioner is already there in custody. The co-accused persons in the present cases have been enlarged on bail. What about the in all the cases releasable? Co-accused persons have already been going to bail. Insofar as the case, the 5 similar cases are concerned, although he was remanded in those cases, however, the trial court have granted bail to all the 4 cases, Therefore, the petition is in fact used for bail, granted bail, and same condition. Yes.
May I submit?
Yes.
May I submit one thing, my lord?
I have granted bail. You don't want.
No. In this case, commitment has already been made. Charge sheet submitted,
All right.
commitment has already been made.
Incision, yes. Yes.
Permission, Interim 55, your lordship keeping it to day after tomorrow.
Not day after tomorrow.
It's
Saturday. Oh, that
Your
keep
lordship,
it 23rd.
Tomorrow, no, not 23rd. Tomorrow, because he has to verify.
Tomorrow he can't verify. Therefore, I give 1 day. Because they will be free by 4:35. How they will contact? At least they should have one. Oh, no, 23rd. Because in any case, you are coming for that matter, other matter. 23rd. Keep it on 30. Yes.
Obliged, Lord.
Yes.
May I permitted to submit on behalf of Mr. Panda, my lord.
Yes.
In this case, my lord, petition is in custody since 9/5/2024, my lord.
9/5/24,
my lord.
Yes.
And in the meantime, my lord, preliminary charge sheet submitted on the 3/9/2024. Offense under section 420, 408, 467, 468, 472, and 120B of IPC, my lord.
Yes.
But earlier, my lord, the petitioner approached the decision court, my lord. Your lordship directed the petitioner to approach the before trial court if charge sheet submitted, my lord. In the meantime, charge sheet submitted. After that, the petitioner moved the application.
What are the allegations?
Allegation, my lord, that the petitioner, my lord, the informant is working, my lord, as a, my lord, the
Accountant.
no, petitioner working as an accountant, my lord. Under the, my lord, builder of the informant, the builder, my lord. The construction work, doing construction work, my lord. Petitioner, my lord, getting 14,000 per month, my lord, working under him. He left the service 2018, my lord. Thereafter, my lord, the company, my lord, the construction company, my lord, the builder, he has given, my lord, all the, my lord, year to year, my lord, the income tax dues, all the other things, my lord. And 2020, my lord, after left 2 years job, my lord, 2020, they lost the information that petitioner misappropriated huge amount, my lord.
How much?
2 crores, my lord, they have stated, my lord. But in fact, my lord, only they have found, my lord, during investigation, 2 checks, my lord. That is self check, my lord. That is on 18/5/2015 and 25/7/2016, my lord. One is 1,20,000, another is 1 lakh, my lord. Except that they have not found any material against the petitioner, my lord.
You deposited that money.
My lord, only, my lord, 1,20,000.
What were you doing? 2018, all this thing. He left the job. 2020, you are.
I'm placing the correct fact. What happened, Milord? In continuously, the present petitioner, Milord, doing misappropriation money, Milord. This 2018, Milord, company sent 20,000 to another employee, Milord. That employee told Milord, I have received only 15,000. Where 5,000 go? When query start, Milord.
You are appearing for the builder.
No,
the builder.
I am not. Yes.
Builder.
Yes. Then no.
You are doing to all other people.
Exactly, my lord.
He did it to you. You are doing to all other people, public, and he did it to you. The same thing. Vice versa. He learned
That
the
is
trick from you.
the real case, my lord. That is the crux of the case, my lord.
What?
He has a power to introduce some persons, my lord.
That 2000.
You give 2 lakh rupees
My lord,
check
okay.
amount.
My
Check amount. Take the check amount.
My lord.
Take the check amount at least. Check only recovered, na?
My lord.
No, total, Milord, 2 crore.
That is not, my lord.
Yes. We have RTGS, Milord, in 2006.
But every year you must be filing your return.
Yes.
Why have you not found the
No,
misappropriation?
what happened, Milord? In 2000,
All are money transaction, cash transaction.
in 2018, it was found, and same day he was removed, Milord. Same day, Milord. Thereafter,
But why have you not filed the FIR?
Exactly.
Yes, there are the internal inquiry, Milord. And after internal inquiry, it was
Oh,
found-
it's a government department, internal inquiry.
That inquiry,
You are builder, all cash
Three years,
transactions.
Milord. And it was found that in RTGS, what happened in this, Milord?
company said two things, my lord. One RTGS, another check. What he did, my lord, in
How much
Canada-
RTGS he has done?
Yes.
To his own account.
My lord,
To his own account. RTGS,
RTGS, he is accountant and involved in doing all the tax matters, my lord. That's some bank matters. My lord. What happened, my lord? Suppose company sent one RTGS and one check in favor of another employee. What he did, my lord, he submitted the RTGS to the bank, my lord, one instrument, money has been sent to that employee. And another check, my lord, he credited in his account and kept that money with him.
How much total?
Total 257.
No, madam. They have not.
In his account.
No, madam. But in the charge sheet, they have not unable to, my lord, produce the charge sheet, my lord. Kind of, my lord, charge sheet, my lord. Keeping open, my lord, charge sheet. For that reason, they have not found nothing, my lord.
Charge sheet copy down my RCD.
Charge sheet is କିଛି ଦେଖେଇ ପାରିଲେନି ଯେ କୋଉ ପଇସା ଅଛି ବୋଲି.
What is ଯାଇଛି ଆପଣ account?
Rather, that is the public money, my lord. When the public demanded the money, he, my lord, the law, the information against the petitioner since he was the accountant, my lord.
Yeah, question rules next week, charge sheet my non
Where have you said that?
2 crore 57 lakh.
ନାଇଁ ଚାର୍ଜ ସିଟ୍ ସବଷ୍ଟାନ୍ସିଏଟ କରିପାରିଲେନି ସେମାନେ କରିପାରିନାହାନ୍ତି ପରା ଦେଖୁନାହାନ୍ତି ଆପଣଙ୍କର
To whose account it has gone?
In account of the present petitioner.
No.
Where does it say that?
No.
Yes.
That is not
Para
there.
14 minutes, as time of which evidence well established.
No. This you tell me this paragraph you are saying 2015-16 87 lakhs.
Yes.
2016-17 73 lakhs.
Yeah.
And 2017-18 75 lakhs.
Yeah.
So it has what are the transactions? You say that it is a NEFT and RTGS.
Yes.
And cash and fake transfer. Cash,
Your
cash
time.
forget about the cash.
Yes.
Only RTGS and NEFT.
Not the direct state real option.
Yes. Who is there? This amount is transferred to his account.
Yes.
But the kind sheet, my lord, charge sheet, my lord. They are unable to, my lord, the substantiated 2 crores, my lord.
Cash
For that is keeping investors open, my lord. Since 10, my lord, 39. 39. And he is custody, my lord,
Both are any bank employee are not.
I'll simply
open, my lord.
When the public demanded money, my lord, they have, but for plot, they have given the money to the builder, my lord. Builder did not repay. And by taking the advantage of this case,
he has transferred it to the different people.
My lord, they have
NEFT and RTGS, not to his account.
My lord, exactly, my lord. Share 2%, my lord.
18.5 paragraph. Charge sheet, have you seen it?
No, charge sheet copy number 9.
See. I'll put it on Monday. Monday, Tuesday, read the charge sheet.
Yes.
If he has, it is not gone to his account,
my lord,
and it has gone to different accounts. Who has done it?
Yes. No. What happened?
Who's whether they are related to him or they are the customer of the company?
That they are each person. We have certain some.
So what are the evidence?
Complaint in his one statement stated that the amount go to others, my lord, not the president.
What is recovered? You say he will deposit and
only 2 lakhs, my lord, 2,20,000. That is my lord, salary, my lord.
We'll see. Yes.
May I please, Lord?
Bail to court will 50.
May I please, Your Lordship? The Lordship, the unfortunate petitioner is inside the custody since 31/3/24, allegedly committing for an offence triable by the magistrate first class.
31/3/2024.
24. Okay. Your Lordship, last 5 occasions CD has not coming, and I have submitted all the documents, all the statements, charge sheet, injury report, everything I have submitted, Your Lordship. Allegation is 493.
When will you get the CD?
Last
expedited these are the bail matters you have to.
Lordship, last 2 occasions they have called. CD was called for.
Last and final opportunities granted to the State Council to obtain the CD.
It will come from Khodda, Your Lordship, may fix to next week.
Yes, he'll fix it. Yes.
This is a case for interim bail, not regular bail. But the case itself is for interim bail. Main prayer is for interim bail. He has been suffering very serious complications of diabetes. Your lordships had asked them to get
You have
a
verified.
copy of the report.
You have to obtain that
My
instruction.
lords,
We have already
3 dates have gone, my lords, and
You have to obtain.
regarding health condition.
That's what, see, I urged the matter on your request on 13th November.
Prior to that.
26th November. Saturday, definitely you get it.
Well,
Interim bail for some period I will give and regular bail, yes.
61.
oblige.
Saturday, yeah? Saturday.
Saturday.
Yes.
May I please, Your Lordship?
61.
I filed a miscase for interim bail. Last occasion, my lord says directed because
Yes, have you verified?
the
Yes.
sister's marriage is on 13th. So there was 4 days program starts from 10th.
Just verify why you.
Sister's marriage is not there. We have got instruction that is sister means brother's marriage. Brother's marriage.
Sister.
Not sister. The brother's marriage was there and already.
And my lord,
solemnized.
No, you be sure.
My lord,
Solemnized.
Whom do you want to get married?
Yeah.
Brother or sister to go out?
Not.
To decide. You say sister, he says brother.
Ayushman Ankit is the son of
Where is your application, Rasi?
Lord, I have
Application? Which is your application?
Recently,
yes.
on 3rd December, we got information that his brother has been.
Brother's marriage.
There and his marriage has
So
already.
his
been
father
solemnized.
Already solemnized.
Yes.
No. Already
We got
solemnized.
information.
ଭଲ କଥା ଏଇ ଉପରେ ନେଇ ନଥିବେ
3rd December 2024, we have.
Where is your application? Show me.
original
Interim bail application.
ଏଇଟା ପୁରା
Interim bail application.
1512 my lord
1512.
yes
What do you say?
my lord kindly see budhwar
Sister of the petitioner is to be
11
solemnized
December
on
2000
Sister of the petitioner is to be solemnized on 13/12/2000.
I have mentioned
Found
sister
to be not
but
correct. Not correct.
brother 11 दिसंबर बुधवार 6:30 बजे फिर पावना प्रस्थान गुरुवार 12 दिसंबर प्रतिभोज शुक्रवार 13 दिसंबर
नहीं, it is हो नहीं सकता है.
My lord, here even your lordship have a glance to the main case, my lord.
No, you are saying your sister's
My
marriage
lord, that
and verification says something else.
typographical
Marriage has already been,
it's
see, marriage has already been done.
My lord, ये अच्छी डेट पूरा अच्छी 13 तारीख 13 दिसंबर. Kindly see page 7 of Miss Case, my lord.
And you are from Rajasthan.
My lord, matter of 50,000. Only 50,000 have been came to my account, my lord. I am ready to deposit even.
Not
charge
50,000.
filed 6 months in custody.
You are involved in a racket.
No, racket.
Hmm.
Have a glance at this affidavit. I have no antecedent, even MSc student, my lords.
Yes, how many cases are there?
No case.
You can see.
Charge sheet filed, no case is there, and I am filing as per your lordship's direction the affidavit. I'm ready to pay that amount even.
Just check it up.
Yes.
Just see this.
Yeah.
Saturday. Verify this.
Saturday.
But local security and all you have to give.
Pardon?
Because your application is dicey. You don't know your
My lord, I am maybe permitted to correct even, my lord, because the typographical error and in place of brother, I have mentioned sister.
Because after he got the instruction.
He
want to wise it.
What I have taken instruction and as per him, my lord, I have never.
So that's, and you are in you are from Rajasthan.
Lord, I have no antecedent, my lord. And
Maybe, but you have to give right security.
Yes.
Verified Saturday. Yes.
Saturday.
Yes, of course. I'll carry on till 2:45 at least.
Well, that matter, last matter for hearing.
Oh.
But can keep it on Saturday Because he's supposed to be filing the case diary, he has brought it, my learned friend, for the vigilance. That is all.
Yes, my lord, I have received the case diary. Your lordship may fix it. Your lordship may fix it.
They'll just give the case diary. Matters almost closed by.
When do you want, Mr. Das?
As your lordship will fix, because your lordship has already fixed so many cases on Saturday.
That's right. Very long list.
There's no other argument to be made, my lord. Why not have to see?
Let it be next week.
Sometime, my lord. I have no problem about next week, my lord. May I just
Monday,
request-
Tuesday, Wednesday.
Whichever day, my lord.
Tuesday,
But I only request, my lord,
Wednesday.
specific-
We'll adjust and give it next week.
And I request, my lord, anytime after 3 o'clock, my lord, pick up. I'll complete in 5 minutes. Let me not. I have the only.
Whenever you give a date, about 3:30 you come.
Item 69.
Item 66. My learned senior is also here for the opposite party informant. May bring any other day. Mediation failed.
Mediation failed.
Mediation failed, my lord, on their version. They did not agree with the mediation.
Naturally, either you might not have agreed or she might not have agreed. Anyway, mediation failed.
On the other side. Any other day.
And note it down and we'll adjust the date.
Lots of.
Entering on to continue.
Monday. Keep it to 23rd.
23rd. 23rd. 70?
70. 70.
70, okay.
Item 69. Other day, my lords, item 63. Will clear the defects.
Defects has not been cured. Defects has not been cured. 60?
3.
Defects in the present case has not been cured. And the issue is 10.
Item 69. 69 can be disposed of, Lord. The husband.
After lunch? Yes. Any, if both the sides are agreeing and give it. Okay. I'll come. Okay.
The husband and the opposite party is the wife. That
Okay.
during the COVID period, she has filed a criminal miscase under that section 12 of the DB Act. That was no notice was served because the entire country was under lockdown. Even if Supreme Court has also given a period from 15/3/2020.
Yes.
That
Somoto 1.
Yes, yes. That
Somoto 3. Somoto 3, Supreme Court. Yes. Yeah, I was counsel there.
Yes, yes. That
what is the amount awarded?
No, that is a totally expiry order. 2 orders are there.
What is the expiry order?
That is 12,000 per month. He is a peddler, just selling utensils, aluminum utensils without hearing.
12,000 per month. What is the due now?
Due something huge amount. Because that order was passed on 27 September.
What is the due? Just show me what are the due amount.
Let's see the expiry order under Annexer 3.
3.
Yes.
Yes.
Order is at page 32.
Have you moved the court, trial court for setting aside the expertise?
Yes, that is Annexer 1.
And that is rejected.
Yes, that petition was rejected only because that good ground was not shown. COVID ground is a good ground, but that ground is not a good ground for which that expertise.
Some other day, let it come on.
No, what I'll do is I'll issue notice. Let her come, we'll see. Issue notice.
Execution proceedings should not.
But subject to you keep on paying the monthly maintenance. You have to pick you. Subject to you keep on paying monthly.
Yes, I will pay that within 3 months she left. Now the amount
That's
is.
right, but she is your wife. You have
Yes,
to
no,
maintain.
I am admitting. I give 12,000 per month is too high. So
I am not going to alter that.
Yes.
The trial court will look into that. But since there is an order already, then
Yes.
you have to keep on paying. Subject to petitioner continuing paying the interim maintenance order passed by the
That is a final maintenance because the expense order.
interim maintenance order passed by the senior
That is
civil judge
JMFC, JMFC Bhubaneswar.
senior civil judge aska na?
No. That is JMFC Bhubaneswar.
By order dated?
That is order dated.
Annex 1.
So 27th September 2023.
23. The execution proceeding pending. Where is that execution proceeding?
Annex 1.
Annex 1 ta rejection of it.
Now you are telling lie. Sorry, you are telling wrong thing. Come to pay Annex 9. The senior civil judge.
That is the petition filed by me against my wife.
That is the ex parte order.
That is also ex parte order. The CS filed a case here at Bhubaneswar. I have filed a case at
Very section 12. Very section 12 ex parte order.
Yes.
Where is
that is under Annex 3.
3. Okay.
Yes.
Annex 3. Subject to petitioner continuously paying the maintenance awarded by the AMFC by its order dated 27/9/2023 in criminal case case number 390 of 2019. The execution proceeding. Where is that execution proceeding? Execution case number 19 of 2024 pending in the court of JMFC. JMFC 1.
Yes.
Bhubaneswar is state. Yes. Issue notice and returnable after 2 weeks. You file the process fee and yeah.
Maybe pardon to mention, my lords. Am I audible, your lordship?
Yes.
My lords, a fresh matter filed today, my lords. The diary criminal appeal number 36676 of 2024.
Yes.
Lordship may kindly accommodate it tomorrow, my lords. I'll be grateful.
What is
my
this
lords.
matter?
This is a vigilance matter. I am challenging, my lords, the conviction judgment passed by the Lanet's vigilance judge.
You send the memo. Please see tomorrow. Yes. Yes.
Very grateful. My lords, I have handed over the memo to the court master.
You give it the memo. Yes.
Grateful,
Next.
very grateful.
16.
My lord.
Yes.
See the recall petition, your lordship. This is petition, your lordship. Recall petition 311.
Yes.
Lordship, kindly see the captain, your lordship. The junior lawyer has filed that petition, your lordship.
Whether you said the lawyer has died or something, you said.
My lord, that has not been mentioned, your lordship. That has not been mentioned, but fact is that the Praveen Kumar Mishra, conducting lawyer of this case, your lordship, he is the lawyer of the.
When he died?
My lord.
16,
I have annexed the funeral ceremony card, your lordship.
When?
That is page 20, Annex 3.
I know when he died. গত 28/7/24
ये साक्षी जो दिन आस्ते 28/6/2024 साक्षी
My lord, except these two witnesses, no other.
when the evidence recorded?
Evidence, your lordship, on 6/8/2024.
6/8.
6/8/2024.
28/7 died.
My lord,
mother of the petition.
Mother of the conducting lawyer, your lordship.
Petitioner moved an application under section 311 CR. The petitioner is accused in FIR number so and so, and facing trial for the same case. When the trial was going on, the petitioner and evidence of who? PW?
1 and 2.
1 and
Victim and the informant. 1 is the victim, 2 is the informant. Mother of the victim.
Boxo is there?
Bosco is there, your lordship.
Then you can't call victim. Who is victim? P1, PW?
1.
1. Right. The victim of the case was examined at PW1, whereas the mother of the victim was examined at PW2.
My lord.
PW2. The counsel defending the present petitioner, the mother of the counsel defending the present petitioner expired on 28/7/2024. the evidence of the witnesses have been examined and recorded on 8th of
6/8/2024.
6/8/2024. On that day,
Funeral ceremony.
on that day, the funeral ceremony, and 10th day of funeral ceremony was being conducted at the house of the council representing the petitioner. Therefore, the petitioner could not, the counsel for the petitioner could not appropriately, could not cross-examine the witnesses at all.
Yes,
at
Lord.
all. Hence, an application under section 311 CRPC was moved by the petitioner for recalling the witnesses. Although the application, the contents of the application is, which is handed over to the court during the course of hearing, appears to be sketchy. No particulars has been mentioned. Therefore, the trial court, by the impugn order dated so and so, rejected the same. Hence, the petitioner, you file press application. Okay?
Yes, Lord.
Hence, the petitioner has hence the trial court has rejected the application of the petitioner. Since the application moved by the petitioner under section 311 CRPC, no ground, appropriate ground was taken. The trial court has rightly rejected the said application. Rightly rejected the said application. In view of the aforementioned, I am inclined to allow the petitioner to move a press application before the trial court, entirely stating all the ground as has been stated in the application. If such application is moved, the trial court should reconsider a past press order.
Yes.
This observation, the petitioner was 311 জায়গা লিখে দেবো।
এটা ভুল লিখিছেন, সেটা applicable হবনি BNS 3.
311, that is also wrong.
That is also wrong, Your
And
Lordship.
you had this application deliberately, you have not.
No, my lord. Later on, পরে মু মাগিছি WhatsApp রে পঠাই দেছি।
Whatever, now you move a press application,
yes, Lord.
giving all details.
Yes, Lord.
So that the trial court will follow.
Yes, Lord.
Yes.
62.
Yes.
Lordship, last occasion issue notice to the opposite party.
My lord, I am appearing on behalf of the opposite party number 2, my lord.
Yes, sir.
Odisha Staff Selection
It's a
Commission.
staff selection commission. And I am filing my Gopalapnama, so also my lord, a reply also, not reply. Admitting the fact that your lordship put a specific question in this case, that whether the petitioner was continuing during that particular interview period. And we have admitted that, my lord, he was continuing on 44 days spell with 1 day break. And that period is, we have indicated that it is from 30th April to 1999 to 30th September 2022.
Document to the court on the basis of which he could successfully demonstrate that the petitioner had been continuing as a junior typist up till the advisory. Series of documents have been relied upon to substantiate the LCA. Mr. Tripathi, the responsible counsel pointed out that the finding referred to the document single day in the impugn order and engineering the 13th single day and non-future to which is the ground that it is not in employment and so on. The relevant paragraph for the finding recording yes. Then it is liable to be reviewed.
But on the order was passed on 11/10/2022.
Yes.
And on that date, my lord, there was no extension and he was not there.
So what do you suggest?
As your lordship put me the question, my lord, that whether the petitioner was in service from 30th.
No. The finding of the learned senior judge kindly see. That I have reproduced that finding.
Yes, I have gone through that.
And that was the finding. The finding is wrong.
With respect to that, he was out of employment for that particular period.
Yes. the finding is wrong. So in that view of the matter, this impugn order is to be liable to be set aside and the writ may be heard once again.
On merit.
Non-merit.
The basis, on that account, my lord, I have not filed any reply, my lord, to that review petition. But just to satisfy your lordship's query, I have not done that, my lord.
No, you have to tell you, are you opposing the review?
No, my lord, on that, my lord, I have no instruction to that effect, but what I found from the review petition itself, my lord, what it has been supplied to me, after the order was passed, a recall petition was.
He has pointed out an apparent error in the trial court judgment, single judge judgment, saying that he was in employment at that relevant time. But the single judge has given a finding that he was not in employment.
But
as a result of which the writ was turned down. So therefore, now since you are agreeing it that he was in employment, I will set aside.
Thereafter, he filed one IA for recall. That was also dismissed. And thereafter, he filed a writ appeal. That was also dismissed as withdrawn. So these are the things, my lord, your lordship may take care of, and thereafter, my lord. But to that extent, that the order person, my lord, of the honorable court, that whether he was continuing in service or
then
not.
you file a exhaustive reply. I'll deal with that.
That is what they are to. But I am.
You file an exhaustive reply. You place it on record.
And I have already served a copy of the same to both.
And file a reply to that. File a reply to that. I'll deal with it, whatever you say. Writ appeal he has filed and withdrawn.
No, writ appeal on the writ appeal, my lord.
What happened?
Writ appeal, my lord, Honorable Chief Justice has said, why file a recall without filing a review? On that ground, I have.
Then the reviews.
What he simply withdrawn and that was dismissed as withdrawn.
That is it, but he filed an IA. Against that IA order, he has gone there.
Yes.
So therefore, the Chief Justice says that you have not, you go. That may be the reason why he has done it.
Why you are not
He's explaining that. You file reply that I'll deal with. If there is an injustice, it has to be cured. That's all. Yes.
Now, what happened? Now he has been removed from.
Don't go into minute technicality, hyper technicality. Just see the single judge order. If he was in employment, he is continuing in the employment. That has to be taken into account. At least that has to be taken into account, and the writ has to be decided on that basis. That's all. I will restore the writ to its original file by setting aside the judgment, and I will allow him to place on record all that document and let the single judge decide it once again.
Once your lordship have already formed the opinion, my lord, then that order may be passed today also.
Yes, your lordship.
He has to. That I'll do it. That I'll do it. I'll give a short date only. 24th, so that I can utilize his vacation to write it. Yes.
63.
Yes. For adjournment, somebody mentioned.
Yes, ma'am.
Yes. Yeah, this matter. Yes. 64.
Item 64, to recapitulate a few things, my lord.
Agreeable to the understanding.
Let my learned senior not be agreeable, but it is my duty to address your lordship as to what has happened. Let him not be agreeable. Look, it's my duty to address his lordship. My lord, what has happened in this case?
That 3 crores issue.
Yes, my lord. Let me complete. My lord will have his say. Let him complete, I'll say.
He should deposit 50
I know, I remember, but what he says something else.
Yes, my lord. Yes, ma'am. Let him not agree. I found it. But ultimately, if he doesn't agree, then he doesn't agree. I mean, his client.
Yes.
Your lordship refer this matter to mediation. Mediation, my lord, we agreed that against an amount of 1 crore 96 lakhs amount, we are willing to pay 3 crores, that is inclusive of the interest. He didn't agree to it, for which mediation failed. Matter was referred back to your lordship. Thereafter, due to the intervention of your lordship, I was not there, my associate was here. Your lordship insisted upon that, no, you agree to this 3 crores. To which my learned seniors, yes, said, we'll agree to 3 crores, provided with certain terms and conditions. Thereafter, your lordship said that there's no point, you exchange an affidavit amongst yourselves, a joint affidavit or deed of settlement as to what are the terms. But your lordship never said that you pay 50 lakhs upfront to show your bona fides. I have also checked in the YouTube records of my lord, your lordship has never said that.
But now it's very dangerous, YouTube.
Yes, my lord, no, that's very nice, my lord. It's very nice.
Yes.
My lord, so now
I only suggested that.
No, so now your lordship may kindly see the
50 lakhs.
affidavit. Your lordship may kindly see the affidavit. So what's wrong with it? Your lordship may kindly turn to
Anyway, I'm
page
not
2.
agreeable to that.
Anyway, it's all right. Let us.
We said
it sounds.
Page number 2. We say that against the 3 crores agreeable amount, we'll pay 40 lakhs within 15 days from the date of the order. Your lordship had posted this matter to 3rd. So within 15 days, we'll pay this 40 lakhs. To which my learned senior says now, no 50 lakhs upfront. Without this affidavit being filed, you pay it upfront.
Not pay deposit.
Deposit. But difficulty is, my lord, unless until there's an order passed to this effect by virtue of this joint affidavit being filed, it'll be difficult on my part to sell that property because I need an order from this honorable court to do the things. The second thing is, my lord, rest of the amount we said that we'll pay within the period of 4 months. To which my learned senior says, and his client says that no, not 4 months, 3 months peremptory. We agree to it, my lord. Then the third, so now the cases.
Now the only problem is
we need a
not 50, it is 40.
So all that we require that this joint affidavit should be filed, pursuant to which your lordship would take this on record, direct that the parties are to comply with the terms and conditions, and let it there be a peremptory order. But unless there's an order, I cannot really.
Why 40? You can make it 50.
Again, yes. But Learned Senior says 50, we'll make it 50.
He's ready.
But he wants, we need an order from this honorable court by filing of a joint affidavit. That's all, my lord. If still my learned senior doesn't agree, let the matter be heard on merits. Yes, my lord.
Your lordship, let me say. Your lordship categorically stated him that he should.
Now he is agreeing 50.
I am coming.
Yes.
That he will deposit the amount on 3rd, 50 lakhs, and interchange understanding between us. So that is my submission is instead of 3 months, we say 4 months. If within 4 months you will not pay, you will file an application for extension, and your lordship will extend it 2 months, 3 months, 4 months again.
No, I'll make a peremptory order. I'll say that no extension shall be granted.
My lord.
And before
tomorrow,
I'll tell you, Mr. Park, listen. The money which is going to deposit, if within 3 months, if you will not pay, I will pass a peremptory order, and that money will be forfeited, and it will go to your, and the case will.
Before that, my lord.
Are you ready on that? At least somewhere you know.
I have agreed. My learned senior is now insisting that without this affidavit being filed, you deposit 50,000.
Either you file affidavit or make it a part of the.
So we require, my lord, we require an order.
On the very day you will deposit 50 lakhs, we will file the joint affidavit. No problem, my lord.
Your lordship may kindly record an order that record an order that in view of the virtual understanding, understanding between the parties, let 15 days time be given with effect from today.
No, I am not agreeable to 15 days time.
Yeah, unless
at least by Monday.
My client requires an order. But
my client is being harassed since 2012.
But in that case, I would say.
If you see, I can only suggest both of you to settle the dispute. If you don't, then it will be heard. I'll hear.
15 days I am not agreeable. If you will deposit tomorrow or at least by Monday, then I am agreeable.
If you have that kind of money, if it doesn't have, then where probably.
But
yes, continue.
Everything let it be heard on merits, my lord.
Lease it for hearing. Interim order to continue. Yes. Till it is open, you can think of.
Yes. A date will be fixed, my lord.
Yeah, date. Interim order to continue. And my lord, this is an application to quashing of the order taking cognizance. Yes. Yes, my lord. Order dated 29/1/2015, taking cognizance of the order passed by the Learned Court below against the petitioner, my lord, who is an empaneled lawyer of the bank, who has given his legal opinion, basing on which the cognizance has been taken on section 419, 420, 468, 471 by 34 IPC, my lord. Yes. My lord, fact of this case is like this, my lord. Notice has been issued? Yes, yes, my lord. Who is appearing?
Lord, it has been provided that this case has been disposed of on 3/3/23. The noting has come up.
Oh, no, no, no. That was disposed of, that was dismissed for default, and subsequently we filed the CRLMA and it was restored to file by depositing. You've not seen it.
No, you lordship, that it has not been provided, and it has been specifically it has been marked as.
Give a copy to him. Lord. Yes. Please, it, sir. Yes, yes. My lord. Appear for? Give a copy. Give a copy, my lord. By tomorrow. I will just, yes. Next week, my lord. Let us see. I'll yes.
67.
Any, I can't hear more. 67. Last
Application. Publication of the stay order. Because an execution case has been stayed, my lords, for payment of interim maintenance to my client, my lords, whose maintenance order has been upheld till the Supreme Court. They have not even varied the order of the original order. The execution case has been stayed. So because of that, my lords, I am unable to get my maintenance. Their entire ground is, my lords, I have agreed for divorce and a permanent alimony, which is to be fixed by a division bench of this honorable court.
Yes.
So, my lords, that will be fixed at whatever point of time, my lords, and permanent alimony, after I get the permanent alimony, certainly I have no right for interim maintenance. But then they have to seek variation of the order under 127 of the CRPC, my lords. My lords, I'm just placing 127 on proof of a change in the circumstances of any person receiving under section 125 a monthly allowance for the maintenance of interim maintenance or ordered under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father or mother, as the case may be. The magistrate may make such alteration as he thinks fit to the allowance for the maintenance of the interim maintenance, as the case may be. Where it appears to the magistrate that in consequence of any decision of a competent civil court, any other order has been made under section 125 should be cancelled, or wherein he shall cancel the order. Or
have you moved any application?
They have never moved any application under 127. They have directly, if your lordship sees, it is annexure 1, page 7. They have directly stayed the orders, challenged the order passed in the execution case without challenging the original order which has been passed under 125, upheld by this honorable court, upheld by the apex court.
Yes, Mr. Go.
Though I am the petitioner, I have the right of first order. But
He's arguing on his application. He's arguing in his application. His application, he has the right to be heard first.
My senior has the right of audience over me. I have no
Always,
dispute on that.
always.
Because the seniority is to be respected. But here is not.
Now, what he says is.
Here is not the case like that. This case is not like that. What is being presented before you?
Now, is it correct? I understood correctly. I understood. A 125 order is passed. What? Let me. What I understood is 125 order is passed. That was challenged by you, which has been.
I did not go for 127. That is the latest view of the honorable.
Show me that.
Yes.
And even if it is confirmed by the Supreme Court.
Yes.
Yes.
Even it is confirmed, yeah, I need not. Your lordship, the facts are crazy because my senior has placed the facts in his own way of the wife. Let me place my facts in the husband's line. My lord, 125 proceeding was filed, in which by order dated 30th of April 2015, the trial court directed 15,000 to the wife, 5,000 each to the son and daughter.
Yes.
That both husband and wife challenged the same in arbitration.
One enhancement, one for,
Yes.
yes.
But the application by the husband was turned down by the High Court. It was enhanced 20,000 to the wife, 10,000 to each of the children.
Yes.
Though my salary at that point.
Whatever, I am not on that. Yes.
That your lordship
Go ahead.
interest.
Thereafter.
It was challenging before the Apex Court. Apex Court did not dismiss
Interfere.
the limit.
Yes.
I was paying up to date.
So 40,000 is fixed.
Yes.
Yes.
I was paying up to
The
date.
son is now major,
Sir,
so
ticket.
no, I'm just saying,
I have
10,000.
not signed any facts, you be rest assured.
Then now 30,000 you.
Yes.
Thereafter, on, my lord, in the month of January, the decree of divorce was passed. 17 lakhs permanent alimony was fixed. 17 lakhs permanent alimony was deposited by the husband.
17.
17 lakhs. They did
17,
not-
17.
One
One,
sir.
sir.
Okay.
They did not accept the same, challenged in matrimonial appeal. I filed a matrimonial appeal for reduction of 17,000. My lord is not hearing the matrimonial, but your lordship was one of the members of the honorable bench which was hearing the matter. There, my lord, your lordship may kindly see order dated 2/11/23, MAPA number 38 of 22.
Now what happened? You just give me idea.
There, my lord, the question was asked, your lordship may kindly see this order.
Yes.
There, my senior Mr. Kanungo considered that we are not challenging the decree of divorce.
By the way, can I hear it? Because I was a party to the.
No, but like, this is a separate question.
No problem. Yes.
There is no clash.
embargo.
Yes.
There is no clash.
What happened?
Consider that he is not challenging the decree of divorce. He is only pressing the amount of payment.
You are also questioning that. He is also questioning that.
Decree of divorce.
No, you will not. But so far as the amount is concerned,
Yes.
irrespective of the
17.
or less than that.
Less than that or more than that.
Yes.
So this was the position.
Question. Yes.
Then what has happened?
Then according to you, the divorce is absolute.
Absolute.
Yes.
Now what has happened? After till the decree of divorce, up to date payment was made to the child and the two children and wife.
At the rate of 30.
Yeah, 40.
40. Okay.
Son became major. The proceedings stopped. Now the daughter has become major in October.
Okay.
That will also stop. That will also be decided by the trial. Now the wife wanted to execute the order of 125 in an execution proceeding after January 2020.
Beyond that decree.
Beyond the decree of there, my lord, the Apex Court has decided in one case, your lordship may see Rakesh Malhotra case. If your lordship permits, I will read through it because it has to be read as a whole.
What is the relevant part?
My lord, you kindly see
Yes.
what had happened. The decree of divorce was assailed before in a first appeal. And 125 was put to execution even after the decree of divorce. There, the High Court, the learned trial court rejected that application. That no, you cannot execute.
So we went to travel up to Supreme Court. What Supreme Court says?
Supreme Court, your lordship may kindly come to page 3.
Yes. Yes.
In these appeals, challenging the decision of High Court notice was issued to the respondent. However, no appearance was entered on behalf of the respondent.
Come to the ratio decision.
Section 25(1) of the Act empowers the court while passing a decree to consider the status of the parties and whether any arrangement needs to be made in favor of the wife or the husband, and by way of permanent alimony and order granting maintenance can also be passed. At this stage, the passing of the decree of dissolution of marriage, the court thus considers only the earning capacity of respective parties, the status of the parties as well as the various other issues. The determination so made by the court has an element of permanency involved in the matter. However, the parliament has designedly kept the window open from the subsection 2 and 3 in that, in case there may be any change of circumstance, the agreed party can approach the court under subsection 2 or 3 or ask a variation or modification. Since the basic order was passed by the concerned court under section 25(1) by.
Come to page 6.
Yes.
Come to page 6.
Since Parliament
Yes.
has empowered the court under section.
That's the law.
2
Yes.
of the Act and kept a remedy intact and made available to the concerned party seeking modification, the logical sequelator would be that the remedies so prescribed ought to be exercised rather than creating.
That's the law. That's the law. The remedy is under the act. If a remedy is provided, you have to reach out to that. No. That remedy 125 against remedy 127. That's what the court is saying. Read it.
In the first page.
Read it full.
Your lordship has to see the facts also.
Such matter, wife would have certainly be entitled to have a full-fledged adjudication in the form of any challenges raised before the competent court, either under the act or the similar enactment.
No.
But reverse cannot be accepted.
Fact.
That's it.
Has to be seen. Why I wanted that I should.
I'll continue. Sir.
When will your lordships take up this matter?
Tomorrow. Because partly I have heard it. Saturday.
Saturday, your lordship. Saturday is not a good day for you.
Saturday.
Next week.
Or Monday?
Monday, Tuesday. The small issue.
Yes.
See, what he says, I'll simply.
The judgment which was decided by the Honorable Court was that during pendency of the first appeal, when the decree of divorce was challenged, their decree of divorce was challenged. In that decree of divorce also, it was 125 was put into press into service.
If the statute provides a remedy, you have to resort to that remedy. As simple as that.
She is challenging not receiving enhancement.
No, that is regarding the element part.
Permanent element.
If there is a distinction between alimony and maintaining.
But if the wife would have been in need, then 17 lakhs you could have taken and challenged in appeal.
Those things I am not interested.
Now,
I am only interested in one thing. The remedy under 227 is forbidden for you. Answer is no. A statutory remedy is available. You resort to that. That's what the judgment is also saying.
No.
If I have correctly read it.
My lord, if I place the entire judgment, your lordship will find it.
Then I'll
It has to be gone in.
Item 69.
My lord, interim order may be extended.
Interim order.
Yes.
Item 73.
I'll give it. Because I have to